Good morning, Your Honor. Apologies, but we had some last-minute IT issues. I think we're all set now.
Don't worry, this thing happens. Good morning, Mr. Nair.
Good morning, Your Honor.
Good morning, Mr. Costello.
Good morning, Mark.
I think, are you all ready to begin?
Yes, thank you.
Yeah. Very well. We will resume the cross-examination. Thank you.
Thank you. Mr. Nair, yesterday we were finishing up the day touching upon the work inspection request log. I don't know if you remember.
Yes.
I'll just wait for this. Yeah, okay. So yes, we were dealing with the work inspection request log. Just so I understand, what is the purpose of logging a work inspection request?
Work inspection request is a QC document. QC submits a work inspection request to the consultant for inspecting a particular work.
Yeah, what's the purpose of the log?
It's just to log what is submitted and what is the status.
So the log ideally should include every single work inspection request made, correct?
Ideally, yes.
We know in this case that the log stops on the 30th of April, 2019.
Yes.
For level 22, yes?
Yes, as per what is that?
What's the explanation for why it stops on the 30th of April?
I don't remember exactly because I'm not sure. Maybe WIRs were submitted and it was not logged in. I'm not sure about that.
So there may have been a WIR, but it just may not have been logged.
Maybe, may not be. I'm not sure about it.
But you can't tell me why it stops. Why, as in why any further WIRs are not logged? You can't explain that. You can't.
Why it's not mentioned in the log, I'm not sure. If any were submitted, currently I don't remember it.
We understand from Mr. Al-Mahdi that the log is Reem's document. Yes?
Yes. Yes.
Who was in charge of completing the log?
We had a QC who was in charge of it.
Who was it?
I remember it was when Mr. Jojo.
Mr. who, sorry?
Jojo.
Jojo.
Yeah.
Okay. Just out of interest, were you a QC engineer at the time?
I was in the beginning of the project.
At the beginning, okay. When did your role shift to project engineer?
Around 2017.
And what's the difference between a QA QC engineer and a project engineer?
QA QC engineer is only concerned about the quality of the works installed. Project engineer handles the daily installation planning of the works on site.
Okay. Would a project engineer spend more time on site than a QA QC engineer?
Yes.
So it goes there. Therefore, we can conclude that you spent quite a bit of time on site. I think you may have said that yesterday.
Yes.
Okay. Who was overseeing document control?
We have a DC who oversees this documents.
Which a document controller?
A document controller. We have a document controller.
And that person is tasked with what the title says, being in charge of the documentation that's produced and received, etc.
Yes. Yes. The QC documents are under the QC itself, but the general documents are under the document control.
Did you ever have oversight of the document control?
No.
You didn't? No?
No.
Okay. And the project manager has nothing to do with document control as well. Is that right?
The document controller reports to the project manager.
Yeah. But what I'm saying is that the two roles are different. The document controller isn't the project manager. They're two separate people.
No.
Okay. In terms of the actual balcony and the roof garden where the swimming pool is, there's a section, isn't there, where the ceiling is a lot higher than when you first come out of the, so when you come out of the room, you go onto the balcony, and then you've got the swimming pool, say, onto the right, as an example. Where the swimming pool is in that garden area, the ceiling there is very high, isn't it?
Yes, it is high.
I suggested yesterday it was about 8 meters high. Do you agree with that?
I'm not sure how much it is. It is, could be. I don't know the exact height.
Why don't you know the exact height? Because you were on site nearly all the time, you were saying.
Yes, but this is not relevant to me. The height of the ceiling over there is not relevant to me because I do not have any work on the ceiling.
All right. But would you agree with me that it was double or more than double the other?
It was a double floor.
It was, sorry?
It was all 2-floor height. There are cavities in the building where the swimming pool is there, so it's 2 floors. The height is almost 2 floors.
Right. Now, in order for the painting to be done on that section, scaffolding would have been required. Is that right?
Yes.
And the scaffolding was for the painting, nothing to do with eaves. Do you agree with that?
It had to do with the eaves because on the ceiling also they have the eave system. After that, they have the rendering and the painting coming over there.
Right. But then that's got nothing to do with Reem's works, does it?
It affects because we have balustrade glass on the roof garden section.
Yeah, but the section where the scaffolding was going to deal with was far removed from where the balustrade glass was.
No. It was within this section.
The scaffolding would have also been required for snagging works, is that right?
If they had any snags, yes, they would require scaffolding.
Okay, so I'm not accepting your answers, but just going by the answers you've given. If eaves required the scaffolding, they would have also required the scaffolding for their snags as well, if there was any required.
For the limited locations, yes. But I understand that the scaffolding, they would have finished the inspections before removing the scaffolding. Because erecting a double height scaffolding again and again and it would be difficult.
Because of the height.
Yes.
So that's why scaffolding was required.
Yes.
And putting it another way, the cradles wouldn't have been enough. That's why the scaffolding had to be used.
The cradles cannot access that location.
Exactly. Yeah. I want to ask you some questions on the glass. I understand that there's no dispute. You heard Mr. Al-Mahdi's evidence yesterday. He accepts there was an engineer's instruction and there was a variation order eventually issued. I'm not going to go into the details of that again. But I just want to ask you about some additional documents. Just bear with me. I'm just going to get them up. So we know that there was some glass was being delivered, wasn't it, in August 2019?
Yes.
And
not sure. Yeah, around that period. Yeah.
And also September.
Yes.
I want to just show you a text message on screen. 1 second. This is from the section called Additional Documents of Relevance. It's M17.
Yes.
Are you familiar with this text message?
Yes.
And this is dated the 15th of September 2019. It's from someone called Santosh. It's with someone called Santosh from Eves.
Yes, he's part of 5.
All right. Who's the sender of this message? Do you know if it's you?
Yeah, I sent the message.
You sent the message?
Yeah. Yeah, I think I sent the message. Yes.
So you're saying here, Eve's level is not correct. Silicon will look too big. Only this area balance. Can you do something?
Yeah.
Yes.
Yes.
This is which, do we know which floor this is?
Level 50.
Right. This is only being spotted in September of 2019.
Mhm.
It's quite late, isn't it, to notice such an issue?
If the area was handed over to us late, we would be looking at these areas and we'll be highlighting the issues over there.
You weren't looking at this. This wasn't handed over to you in September, Mr. Nair.
Mhm.
This was handed over to you months before this.
Not necessary. If they have any works balance, it could be balance over there. And you don't have any proof saying that this particular location was handed over to me months before.
Oh, hang on. We've got the closeout program.
Mhm.
Do you want me to show you the closeout program?
Okay.
Okay. Bear with me. It's at G2954. Just bear with me. I'm finding it. So this is the, okay, let me try and zoom in a bit. Is that better? Can you see that?
Yes.
Good. This is, I'm just familiarizing yourself with this document. This is the closeout program. This is the 30th of April, 2019. All right.
Yes.
This is level 50, as you said, is on page G2954. I think I may have already said that. And certainly by this stage, which would have been the date that Reem was going to do its works, if we follow the table, that would be it's either the 1st of June or 2nd of June. I need to look at it. I need to follow it exactly, but it's either the 1st of June or 2nd of June. So I'm trying to cross-reference it as best as I can. Yeah, 2nd of June. This is the closeout program. Yeah.
Mhm.
So this says, and by the way, just so you understand, the Fives case is that access was given before this date, but I'm just taking you through Reem's own evidence that was produced. This shows that certainly in June, you were on you were supposed to be on level 50.
Yes.
And as you said yesterday, the snagging works took place in June and July, and the de-snagging works. Yes.
Yes.
And we looked at some other flaws with Mr. Al Mahdi yesterday, and that was the handover documents. I appreciate, and that included some flaws between 41 to 59. Do you remember that? And that was back in April, May, and June, early June. Yes.
Yes.
Right.
Yes.
So now that I've had to go through all of that with you, and you said that there's no evidence to show that Reem had access, do you agree with me? Reem had access as early as, well, on your case, as early as April.
So this could have been highlighted during July, June, July also. On site, it could have been highlighted. Maybe it was not completed at that time, so we re-highlighted again. When we noticed it again, we re-highlighted this issue.
Mr. Nair, let's just stick to what you remember for sure. We've got the WhatsApp. I showed it to you. That was in September. You said that access wasn't given until September. Do you now agree?
Access was not, I did not say access. I said the work could not have been completed. Maybe Eve's work was balanced over there in that location.
Can you say access? Sorry,
Again,
bear with me one moment.
Okay, sure.
All right. certainly I suggest to you that that Reem should and could have noticed such a mistake or, you know, error with the work from Eves a lot
Yes.
sooner in September. Do you agree with that at least?
I agree.
So I didn't catch that answer.
He agrees.
I agree that we would have caught this issue earlier and would have highlighted to 5.
Sorry, Milo, I'm just checking through something very quickly. Yeah, that's already been confirmed. I'm going to show you page M19, which is a WhatsApp. Again, this is dated 24th of September 2019, again with Santosh. Yes?
Yes.
And again, these are messages from you.
Yes.
This is mechanical floor. That's what it says.
Yes.
Again, I hope we can just get straight to the point. Again, I think you're trying to identify maybe some errors here. Is that right?
Yes.
This again could have been and should have been notified a long time before September.
This should have been notified, or this area was not handed over to us. I don't remember exactly what happened during this time.
Well, it was handed over before September 2019.
This is the mechanical floors. So
That's what you've said here. Yeah.
Yeah.
Yeah. And I'm suggesting it was handed over before September 2019.
If I'm not sure when it was handed over, but this was sent to them on September 2019. And if it was the case, we had access to this area only during this time. And as you can see, the eaves work is not completed there. The rendering, the alignment, all those things are balanced over there.
Okay.
So it means their work is not completed there.
Okay. The mechanical floors, is that 39, 40?
Yes.
And is this 39 and 40 that you're referring to here?
I believe so, yes.
Okay. I hope you'll just take it from me because I want to try and save time, but the reference is again 2954. We looked at it a moment ago. Levels 39 to 43 was scheduled for works for Reem at the end of May, 26th and 27th of May. And you said yes. I don't want to go through.
You are referring to the closeout program?
Yes.
The closeout program is not valid on the external side. It is only for the internal side sections, which directly affects the hotel operation and their arrangement of their joinery and ID works and all these things.
I'm suggesting to you that this is evidence of Reem not of notifying 5 later than it should and could have.
This is evidence of 5 have not completed their work before handing over to Reem. That's what is clearly evident there. Their eaves work is not finished even in September. That's clearly evident from that photo.
Okay. I want to deal with something that came up yesterday. I understand that in February of 2018, correct me if I'm wrong, Ahmed Daraz was the project manager. Am I right about that?
Yes.
February 2018. Yes.
Yeah.
Did you have any, were you involved in the putting together, I'm going to call it, of the prolongation costs claim?
No.
No.
No involvement.
Right. Are you familiar with the documentation?
I have seen it, but I cannot comment on it because the contracts department, along with the project manager, does it. So I'm not really sure.
Okay. The reason why I want to ask you is because your name features on it. So I'm going to show it to you just to see if it if you can assist. And this is page 8E, E for Echo 831. To give context, I'm just going to scroll through this relatively quickly just to remind everyone what we're talking about. From E826, this is the 8th of February 2018 submission. You may remember there was some cross-examination about this yesterday. My learned friend re-examined Salim Al-Mahdi about this.
Yes.
And you'll recall that there was a reference to C details here in this table.
Yes. Yes.
And my learned friend sought to clarify what that meant. And Mr. Al-Mahdi said that this is the table.
Yes.
And that there are names of individuals, etc. But we can see you here, Harish.
Yes.
There. Yeah, sorry, I you excuse the mispronunciation. It's put you down as a QA/QC engineer.
Yes.
Okay, and we've got your details down from November 2017. And bearing in mind the date of this letter is the 8th of February 2018, we've got you down here, February 2018, and it still continues well into 2019 for costs that have not yet been incurred. So I just wanted to know if you understood, if you knew why that was the case.
I cannot comment, actually. I'm not sure what you're asking. I cannot comment.
Well, as I say, we can see you're down here. Your name is down here.
Yeah.
The date of this letter is the 8th of February,
Yes.
2018. That means, putting it very simply, events in March 18, April, May, June, July, August, September, October, November, all the way through to 19 have not yet occurred.
Okay.
Okay, but costs are being claimed for your time and wasted time for the prolonged period.
I'm not sure, actually. I cannot comment on this.
You weren't consulted about this at all?
I cannot comment on this document. I'm not involved in the preparation of this document, so I cannot comment.
Oh, okay. I appreciate Ahmed Derez signed this off. I
Yes.
appreciate that, but of course you were working with Ahmed Derez, weren't you, at that time?
Yes.
So you didn't speak to him at all, no?
Regarding this, no. No.
But we know that this letter was submitted to the engineer.
Yes.
Okay. Do you know how many? Sorry, let me just take the screen share off. How many QA/QCs were working on site in, say, let's just take it in stages, from after the fire incident up until the end of the year, so August 2016 to December 2016.
2.
Okay.
August to December, correct? 2016.
Yeah. August 16 to December 16, too. So Jan 17 to December 17, how many QA/QCs were working on site?
2.
So that's from January 2017 to January 2018. Sorry, forgive me. Let me start again. That's from January 2017 to December 2017. That was 2, yes?
Yeah.
Now, Jan 2018 to December 2018, how many QA/QCs?
Mm, 1.
Okay. January 19 up until October 20, let's say October, November 2019. How many QA/QCs?
1.
Just 1. Just hold on one moment. that a fire alarm? Sorry, my lord, there's an alarm ringing. Just wanted to make sure it's not a fire alarm. I think it's gone. I think we're safe. Okay.
Well, let me know. Let me know if it goes off again.
Yes, will do. Thank you. Yes. All right.
Sorry.
Thank you very much. I don't have any further questions.
Mr. Carvelis, do you have any questions in re-examination?
Very few and one comment, if I may, Your Honor. I have to say that my friend was not very proper during the last part of the examination of this particular witness. The way the questions were put in relation to the document that he asked the witness to testify about were not really proper. I'm sure my colleague understands very well why this particular document has a projection of expenses until the end of March. I cannot understand that he can't know that it is the extension of time, calculation of the extension of time claimed until the date on which the contractor requested an extension. It is a projection of costs. I'm sure my colleague is entirely aware.
All right.
I will leave it there for now. Mr. Nair, one very quick, very few questions, and they will be about the closeout program. I don't think that we need to have it on screen again. I think we all know what it is about. Can you clarify one thing with me, please? This closeout program, is it the planned? Is it what it was planned to be done, or is it what actually happened, or is it the as-built situation?
It's a plan.
So what it was supposed to happen, right?
Yes.
It did happen, what the closeout program provided?
If I remember, it did not exactly follow the plan.
Right. My colleague showed you some pictures. I'm happy to show them again, but I don't think that it is really important. I'm sure His Honor and everyone remembers them. In these pictures, do they, in your testimony, in your understanding, do they show that all works on which Reem was dependent were completed or not?
They were not completed. As in, the works which had supposed to be finished before Reem were not completed.
Okay, and then the particular messages that were sent that my friend showed you and which had mid-September as a date.
Yes.
Was the hotel open at the time?
Hotel was open.
The hotel was in operation. Was it easy? Could you access any room you wanted at your own discretion, or did you have to ask to arrange this with a hotel manager?
We had to arrange prior permission.
And how did you have access to the room? What was the means to have access to the room? Did you have to use the BMU?
We have to use a BMU.
The BMU. And could you just decide when you will take the BMU, or did you have to arrange it with the hotel manager beforehand?
We had to arrange. We had to coordinate with 5 engineer and arrange it. They would arrange it with the hotel manager.
So what's the BMU?
Business maintenance unit. If I understand Your Honor, that I stand to be corrected.
Building maintenance. Building maintenance unit.
Building. It's this, how you call it, this platform that hangs from the top of towers and it goes down to wash the windows.
Yeah, thank you.
So that was the means to have access. No further questions, Your Honor.
Well, thank you very much, Mr. Nair. That's the end of your evidence. Thank you very much, and you're free to go now. Thank you.
Thank you, Your Honor. Thank you.
Now,
Sorry, my lord, I'm hearing the alarm again.
let's take 5 minutes anyway between witnesses. The
Yes,
next
thank you.
next stage will be Mr. Akiki to finish. But we'll take 5 minutes now.
Yes, thank you. It'll give me time to find out what's going on here as well. If anything happens, I'll get a message.
Well, we'll be around.
Thank you. Thank you.
Thank you. We were disconnected and had to reconnect.
Don't worry, that happens. Worse things have happened, and we've survived. Thank you. Is Mr. Akiki available now?
He should be. He's on the call.
Right. And your fire alarm has gone off.
The fire alarm is being inspected, but
Right.
at the moment we're safe.
Okay. Good morning, Mr. Akiki.
Good morning.
Welcome
Good morning.
back.
Thank you so much. Thank you. Good morning, everyone.
Right. Mr. Carvelis, I think you want to resume cross-examination.
Yes, please. Thank you, Your Honor. Good morning again, Mr. Akiki.
Good morning, Angus.
Let me start by saying that I think I was a little bit rough the other day.
I did not feel that. To be honest, I did not feel that.
Anyway, if it makes you feel any better, and I won't mind if you don't, I wasn't much nicer with Mr. Salim, who is my client's witness. You know,
Thank you.
and that's how cross-examination works. We have a script, right? List of questions. And we always, I'm sure my friend will confirm, we always struggle to make sure that we ask as many questions as we can. We never do. We never ask all of the questions, but as many as we can. So, and I should have asked you perhaps before, I should have explained it before. I don't know if you have the privilege to be as a witness in a trial before. But, you know, I have questions which some of them one lead to the other. Some of them will require a yes or no answer. Please indulge me. And I promise you, once I finish with a set of questions, you will have every opportunity to express your opinion. Tell me that my question is stupid. I won't be offended. And I'm sure the judge will make sure that you have this opportunity. So let's try and work together. After all, we're all here for the same purpose, for the judge.
Absolutely.
So let's try and work it out. Let me start with an issue which occurred during the last part of the cross-examination of Mr. Nair. We will show you, although I'm sure you know it, we will show you on screen a document which is in bundle 8E Echo 826. It would be a very quick question. It is the letter of Reem to the engineer dated 8th of February 2018. You may recall that it is a document that you have produced. It was an exhibit to your witness statement.
Yeah.
I think it was NA12, if I'm not mistaken. So this is a document in relation to the Reem's claim for prolongation costs. I won't ask you if you agree or you disagree with these numbers there. This is not the issue. All I would like to clarify is the following point. If we scroll down this document, if we scroll down and we go to page 831, right here. If you click Control Plus, it will make it bigger. Should make it bigger. Yes, it did, but you need to. There, okay. I will try to help you. This is a table with the description. The column description has the position, the corporate position of Reem's staff, project manager, survey manager, surveyor, HSC officer, then names, and then there are the columns which start from November 17 and they go all the way to the March 19. And these are columns with numbers, which are what Reem argues that they are the direct cost, what they call as direct cost. And again, it's not an issue to discuss whether it is or it is not a proper number. As I mentioned, as you know, the letter to which this table was attached was dated 8th of February 2018. However, it includes figures that start from November 17 and go on until the date of the month of the letter, February 18, but then it continues until March 19. Why is it? Why do we have figures here until March 19? Do you have an explanation? Do you know? Can you explain us why this table includes figures, regardless of whether they're right or wrong, until March 19? Is it perhaps, if it helps, is it perhaps because this table is the quantification of what Reem considers as prolongation costs for the extension of time that they requested before until March 19? Is this what the table about? What this table is?
Yeah, I will wait until you finish, Mr. Karvelis. Yeah, go ahead.
Excuse me?
No, I'm waiting until you finish. Sorry, I tried to say.
This is my question. I mean, why does this table include figures from November 17 to March 19? That's my only question.
Yes, I have the same question. If Reem can explain to us why these dates are there, it will be great. Because this table has been prepared by Reem. And if I'm not mistaken, this is the extension of time that they have prepared, the extension of time due to the fire incident. So the right party to ask why they have included these dates is Reem. Till now, I do not have any idea why in the extension of time, which is related to the fire incident that took place in 6th of August, 2016. I have the same question of you, sir. So if we can have clarity from Reem, it will be great.
Okay, that was not my question. So we don't have the same question. I know why they included these figures there, or I think I do. My question is different, and I think you answered it. I think you gave the answer that I was looking for. These are the figures that Reem considers as correct. We don't know if they are correct. I'm not asking you, and I'm not submitting that they are correct, but these are figures which they say correspond to their costs until the date for which they ask the extension of time. It includes projections, in other words, right?
Yeah. Yes. In this context, I think this was their intention, but I cannot confirm.
Okay, thank you. That's just clarify, because there was a little bit of confusion when my friend asked questions to the previous witness earlier. Right. Let's go back where we left. and let me recap what we established on Monday. I'm talking about, I'm still on the issue of delays. What we established on Monday is that based on your analysis, which you provided for the benefit of the court, it is in document E for the bundle E, Echo 1094, Your Honor. Your position is that the works of Reem were dependent on concrete eaves and tiling works, and these works, concrete eaves and tiling works, were completed. The latest were the roof garden eaves works, which were completed on 3rd of March. I'm sure you see second line. I'm sure you can see second line. Roof garden eaves completion, brackets factual date, 3 March 2019. This is what we established last Monday. Am I correct?
Yes, that's correct.
Yeah. Thank you. Right. Let's see now. Again, let me display an image before you, which is dated 19th March. This is in bundle F477 to F479. You may recall, Your Honor, this is an image which we said earlier. This is a letter. If you can scroll back at the top. This is the date of the letter is 19th March 2019. It is a letter from Reem to Atkins. Do you see this, Mr. Agiki?
Yes, I do.
Okay, now attached to this letter, there is a photograph. This is not a very clear version of the photograph. We have a clearer one, which we shared with our colleagues and the court yesterday during this was an issue first raised during the examination of Mr. Ahmadi. Do you see this now? Do you see it now?
Yes.
And we changed it. Do you see, can we put the cursor of the proper? Okay. Are we done? Okay, let's this point here. Do you see the cursor, Mr. Agigi?
Yes, I can see.
Okay. Are eaves works completed at that part?
The eaves work. No, this is the preparation for the eaves. It's an ongoing work hand by hand with Reem, because there are some activities required by Reem, and then the eaves will come as per the description of Salim, Mr. Al Mahdi.
So on 19th of March, eaves work were not completed. I will now take you to page 47. I will now take you, sorry, to page. I will display another email.
Yeah.
It's at F3025 to 3026. Right now, this is an email which has a table, and we're attached. And this was reviewed yesterday during the examination of Mr. Al Mahdi. Can you confirm that Rijaz Bashir is an engineer of 5?
Yes, that's correct.
So he's involved in planning and execution of the project, if I'm not mistaken.
That's correct. Yeah.
And this is an email sent by Mr. Rijaz to Mr. Harish of Reem, indeed, and it is dated 27th of May. Do we agree on that? I think we can agree on that.
Yeah.
Day. Now, if we go now to the next page, this table here, this is a table which was forwarded by your engineer to Reem's engineer. Would you agree with me that this table notes that Abe's works were planned for all floors of the building from level 15 up and were taking place from 15th May to 17th of June? Is a correct statement?
Yeah, these are the closeout around the aluminium balustrade and glazing. Yes, I do agree. But these are not the eaves work. These are not the eaves work which I mentioned in my delay schedule. So I will explain. You will give me the time to explain this. You promised me this, and I will wait. I will wait for this. I will wait for your permission to explain to you.
So what you mean is your delay analysis, to save time. So when you say at your delay analysis that roof garden Abe's completion factual date 3 March, by the way, at the top of this table, we see roof garden Abe's plantation completion.
Yes.
Right? So I assume when you say your delay analysis, roof garden Abe's completion is the same here. Roof garden is the same, not Abe's works. Roof garden is the same. There is one roof garden, I guess.
I need to explain this instead of staying in the assumption. I prefer to explain this whenever you give me the time. I'm waiting for this.
Okay. So what you're trying to say is that in your delay analysis, your roof garden Abe's completion factual date are different Abe's works, not those Abe's works.
If you assist me, please, to go back to the picture that you put, the overall building, I will be able to explain for you that. Yes, please. So, yeah. So you see, the discussion was maybe half an hour ago with Mr. Harish that the double height above the swimming pool are 8 meters and so on. You can see that all these surface, which are the biggest surface within the building, in the terrace area, in the garden area, above the swimming pool, these are constituted of eaves work, which these eaves works have to happen and have to finish before the Reem, they can finish their stick curtain walls and the sliding doors. However, the strips that we are seeing, you can see the strips which there are some parts of them are not completed. This is correct. These are also eaves, but these are depending on Reem to finish their glass balustrade rail and the installation so they can close. So what I'm trying to establish here, a differentiation between the work of the eaves in the terms of completing the whole building, which took place in March as per my delay analysis. And these are...
Celine, is it alive?
Excuse me, no, I can hear you well, Mr. Agnetti.
No,
Don't mind.
No problem. No problem.
Stuff.
Yes. So I think I'm not sure if it's clear. Yes, where the mouse is, these strips which are still pending work for the eaves, these are pending because of the delay of Reem. So these are the closeout of the facade. Yeah.
So again, let me take you back to the delay analysis.
Yes, please.
If I may. It's your document.
Yes.
We have it. Delay analysis. I'm tempted, by the way, to ask Mr. Ahmadi to comment on this, because I suspect that he will show you additional points, but I might ask, Your Honor, I might have to come back to this, and I might have to ask your permission to have Mr. Mahdi and Mr. Akiki sitting next to each other to clarify some factual issues. We'll see. Now, but let me go back to the delay analysis. So, again, what the line number 2, I will read first the box, which is above the lines. Below chart shows when the concrete, eaves, and tiling works have been completed as per factual completion dates, and Reem glass works, that's your words, not mine, should have been completed, which is agreed 12 days after.
Yes.
These are your words. I didn't put any words in your mouth. And now we have the second line, which says roof garden age, completion date, factual date, 3 March. Do I read this correctly?
Yes, you are reading correctly.
And you say now that, well, actually, you didn't mean all of Abe's works. You meant part of Abe's works.
No. What I meant is exactly what is written, Mr. Carvelis. It is written roof, gardens, eaves, completion between between 2 brackets, factual date. So I mean the roof, garden, eaves, which it's the majority of the work, which is above the swimming pool, the double heights, all these walls. Yes, this is what is written here. So, and this is written based on the schedule that we have signed in the subcontract agreement as an attachment. So I'm basing my analysis based on the subcontract agreement. However, the other area that you are pointing out now, which is closing around the facades, this is hand by hand with Reem progress, and that's why it was delayed.
So you mean the balconies?
Yeah, not the balconies, the edge of the balcony and the terrace, which is in the picture. Yeah, the edge.
So the edge. So it's not part of the balcony.
Yes.
So let me say that there is a range of dates. That's what you're saying.
Yes. The range.
Okay, let's go up to this.
Yeah. Okay.
Let's go up to the. If we can scroll up in this document. So the range, I assume, is the scheduled completion date, which for Abe's completion schedule was 23 June 2018 based on the program, right?
That's correct.
And then we have, you present the factual date. I think we can agree that factual date can mean only one thing. It cannot have many meanings. The word factual date. I'm glad. So it's 3 March, the factual date. Completion was effected. They were completed on the 3rd March. But you say now that, well, that's not all of it. These are not all of the Abe's works. These are part of the Abe's works. You did not include the edge of the balconies. You see the 3rd line, balconies. It's balconies, but without the edge of the balconies. Okay, yes. I would like to agree with you on this. Show me anywhere in this, in the remaining 11 pages of this analysis, where you show the requirement for the balconies, for the Abe's works. Where did you show these works in your analysis?
This is not shown in this analysis because this has been delayed because of Reem. So Reem has caused this delay. So that therefore it doesn't make any relevance to show when this has been completed after then Reem they completed. So I put the milestone which is in the schedule that has been agreed and signed in the subcontract agreement, and it's exactly the roof, garden, eaves completion. So that's why I referred to this part, and I was very clear in my description. I did not try to say the roof gardens, including the edges of the building, which are related to. Yes.
So what you're saying is that you should have added the words included and not the words excluding the parts that are not displayed. When did you prepare this delay analysis?
Sorry, I disagree with the statement that you said. I did not mean that. So, however, yeah, please.
You mean what you mean is on record, Mr. Akiki. It is recorded. There is a transcript.
Yes.
But answer this, please. When did you prepare this delay analysis?
This delay
When?
is, can we see if there is a date for this document? I don't recall exactly when.
Let me put it differently. Was it prepared in 2019 or in 2022?
Between 2019 and 2022, there are 2 years. Sorry, yeah.
Okay, is it a recent document which you prepared for the purpose of this trial, or when did you prepare it? Because frankly, it does not have a date, but it is mentioned in your witness statement that you prepared it for the trial. So I'm just trying to confirm.
Yes.
So you prepared it this year,
correct.
sometime this year.
No, that's correct, but I don't recall the date. But yes,
Okay.
I prepared it for the trial. Yes.
It doesn't matter. And when you prepared it, you looked at everything, right? All the documentation available.
Yes, I refer to Mr. Al-Mahdi's statement that the eaves and the concrete and the marble has delayed them, and that's why I went to exactly where they guided me to see how this delay impact.
It's a simple question. You took into consideration everything.
Yes.
Yes, and presumably. The letter that we showed you with a picture, if you can go back.
Yeah. The picture has nothing to do with the delay before Reem. The picture is the result of the delay of Reem. This is what I'm trying to explain. Yeah.
Well, it is slightly different though. It would be convenient if it was like this, but it's slightly different because the picture shows that, which you had it, as you say, you saw it, as you said. Can we go back to the date of the letter? Right? It is 19th March 2019, right?
Yeah.
And this is a critical letter because it is a notification of delay in providing clearance to complete sealant works. It's an important letter, presumably. I guess you find it important. And this letter had this picture. So when you use the words roof garden, eaves completion, factual date, you knew about it. So what you're saying is that no, if I wanted to mean additional eaves works, I would have added the words included. What I say is that what you just confirmed not only does not stand to reason, it is so ridiculous as an argument that it is insulting common sense. You have based an entire analysis in order to claim 20 plus million dirhams on the factual statement that the eaves works were completed on the 3rd of March.
Yes.
But you come now, not even in your reply with the statement, by the way, not even in my colleague's skeleton arguments, by the way, not even on day one of your examination, by the way, but only after day one and only after the examination of Mr. Al-Mahdi to come with, I have to give it to you, quite
Please do.
interesting interpretation that when you said roof garden age completion, you meant some, not all, and if you wanted to mean all, you would have said so. That's what you say.
Can I say
If
what
you
I
want?
I need to answer, sir. I'm still waiting when you give me the chance to explain, because I still believe the delay analysis is very factual. It is referring to a milestone which is stated clearly in the schedule that we have signed and attached to the subcontract agreement. There is no manipulation. It's black and white in this item. I'm not trying to cover or to hide anything. However, any delay that took place because of the Reem delay, and also I would like to go back to your letter that you are mentioning, I mean to Reem letter 19 March 2019, and I would like to read clearly the title, the subject of this letter, which is saying sealant, aluminum, the balustrade sealants. So in terms technically, when we say a sealant of a glazing, this is the title of the, yeah. If we go to the subject, okay, the sealant work, they are not complaining that the eaves have delayed them to install their balustrade. They are talking about the sealant. And when we go back to Mr. Al-Mahdi description about the steps, how these balustrade are being built, you will see clearly that these edges of the building have been delayed by Reem. So why shall I put in my delay analysis an item delayed by Reem in order to prove that there is a delay by Reem? Already the delay has been established based on the milestones which are contractual and we have agreed on in the subcontract agreement. So I'm just clarifying this. It's not that I'm coming with interesting explanation. These are again explaining the facts.
I agree it's black and white, and it's on your delay analysis. It is black and white. I agree entirely. But because, you know, as I said, it's a matter of common sense at some point. Okay. So you say you meant balconies, but you excluded the edges. When you say balcony saves completion, exclude the edges. Exclude the edges.
Actually, it is. If we go back,
this is what it's simple. When you say balconies, age completion, factual date, 28th February 2019, you say that you meant to exclude the edges. This is what you say.
Yes.
But you did not think important to mention it.
No, it is not. It's not relevant. I did not say it's not important. I said it's not relevant to the delay analysis because these items have been delayed by Reem themselves due to the sealant and the phases that have been done there. So that's clearly what I said.
Black and white, and I totally agree.
Thank you.
By the way,
yes.
What's the normal process? Eggs first, glass after, or the other way around?
We can go to the steps that Mr. Al-Mahdi has described.
I asked on your experience in the standard practice is eggs first, glass after, or the other way around, or glass first, eggs after. Very simple question. Standard practice, what is it?
Can I speak? Yes. So there are different items. Some items, the eaves is required before the aluminum framing and before the doors, the windows, which are related to the balconies and the gardens, and that's why there I went with the proposal of Reem by saying, if the eaves have delayed us, we are not responsible. The eaves have delayed us. And that's why I put the factual date of the completion of these, because these are to be done before Reem. However, when we speak about the balustrade and
you don't answer.
I'm answering.
Finish.
I am answering.
You finish, please, Mr. Kiki.
Thank you, my lord. Thank you. So when it comes to the glass balustrades and the installation, there it is not the same situation. Eaves is not delaying Reem in these areas due to the description of how they install the U channel, which has to be grouted, and after the glass, and after the eaves, and after the sealant, and after the cover. So this process is very clear. We are talking about two different items. I cannot answer yes or no for all the eaves everywhere across the board. So this is a technical thing.
So-
That's why I took my time to answer in two different ways. Thank you. Thank you, my lord.
Again, it's black and white.
Yeah.
Why I say that? Mr. Ahmadi said that, you know, the standard industry practice is finish with AIDS, we put the glass so that the AIDS contractor will not damage the glass. We finish with the glass, then the AIDS contractor comes back to do their final, and we put the cover. Maybe, maybe we don't need the AIDS contractor again after we put the glass. I may be wrong, but the important thing is that AIDS first, glass after, so that the glass is not broken. Mr. Ahmadi testifies that, and we'll discuss this, because the AIDS contractor you originally hired was useless, you changed it. You appointed a new one. And there was a lot of delay. And in order to help you with the delay, and because you were very eager, you proposed, you asked that they change the sequence. Glass first, AIDS after. And then cover. So, what was the result of that? That they broke glasses, they broke panels, 150. It's not a small number. I'm sure you agree with me.
Yes, I do agree.
150, because the work that risked damaging the glasses was performed after the glasses was installed. Do we agree on this at least? It's a fact.
Here I need to explain something. Go ahead.
Mr. Carvelis, if you ask a question, allow the answer. You can't interrupt.
Yeah, but I need to, in order to ask the question and have an answer on the question, I think I have to put the context.
Mr. Carvelis, you, in the middle of your speech, you said, do you agree on this? And then he was trying to answer yes or no, or maybe, but you didn't let him answer. Okay.
Apologies.
Mr. Akiki.
Yes.
You want to answer that point?
Yes. Sorry. Thank you, my lord. So, shall I answer the?
Just the point you were being asked about, whether you agreed.
Yes. Only this point regarding the 150 broken glass balustrade. Reem, they have already admitted that part of this, it is their responsibility, and the majority of the other part is by other contractors, sometimes the cradles, sometimes the eaves, and we never deny their right to be paid for the part which is not responsible. We are not arguing with this. We agree on this. However, the number 150, Reem themselves, they said out of this, there is an amount which is our, we broke it while installing it. So that's a fact.
This is not an answer to the question, Your Honor. I have to address this to Your Lordship. This is not the answer to the question. This is now the answer about the variation order for the 150 classes.
Mr. Carvelis, the problem is you asked a very long question and in the middle of it several times said, do you agree? Now, if you want an answer, do you agree? You let him answer. If you don't want an answer, then don't ask, do you agree? Is it simple as that?
Yes, but my question, whether he agrees that 150 panels are broken glasses are a lot. That was the question.
Yes, which
I asked him to agree. I will deal with the variation order later on.
Well,
promise you, I promise you.
Try, Mr. Carvelis, and keep your questions a bit shorter, and then you have this confusion.
Okay.
Thank you.
I will. So, do you agree with me, Mr. Akiki, that at some point the sequence, I'm not saying who changed it, the sequence changed. And it was no longer Aves first, glass after. It was glass first, Aves after, cover last. Do we agree on this?
I would like to refer you to Mr. Salim description about the phases. This is established because it's not that simple the way how you are describing, sir. I'm really sorry. It's not only eaves and balustrade. There are rails, there are grouting, there are even set out. Okay, you know what is the surveying set out? So this is all done by Reem before than any other activity. So I prefer to stick to what Mr. Al Mahdi has described, which is more accurate, more technical than to say eaves first, glass first, or eaves glass first.
I will agree with you.
Thank you.
I will agree with you. I'm happy to agree with you. I'm happy to agree with you. But the point remains. Include whatever else you want. Aves first, glass after, Aves first, to be followed by glass, and anything else in between, fine, to be followed by cover. Do we agree on this?
No, definitely not. And I explain if you give me time. But my short answer is no.
Okay, I will give your short. I will give you a short answer.
Thank you.
Sorry, which one is it? This is which one? By the way, yeah. What I just described, the way I described it, by the way, is Mr. Al-Mahdi's witness statement. You see this footnote? It is paragraph 17 of his, I think, of his first witness statement, which is the paragraph that you agreed with in your reply witness statement, and I showed it to you.
Yes.
I showed you the paragraph on Monday.
Yes.
I showed you where, in your own words, in your own witness statement, you disagreed. None of what we are discussing is a point that you disagreed. None. You said in your witness statement that the description of Mr. Al-Mahdi of the works, which is what I was trying to argue, is correct, not me. If I'm honest, I get half of what you can understand. I'm a lawyer. I'm not an engineer. I'm not an architect. I'm not any of that. I'm a lawyer. For me, I had to look at the vocabulary to understand what Louvre and balustrade is, and the eaves and sealants. You agreed with the description of Mr. Al-Mahdi. Why I say this? Why all this? Because the picture we showed you is Eve's work after the glass. So when you mentioned in your delay analysis Eve's work completed, you could only mean, if you intended this to make sense at least, Eve's work as agreed to be completed, i.e. glass first, Eve's after. And the only remaining item of work for him would be the cover. Am I clear so far?
Yeah, you're clear.
That's all. And we can now move on to the next item, at last. Let's go to document F1889.
What's the dollar?
It is the instruction, 30th of July instruction. This is the variation order. Variation order number 4. While trying to find it, it is, I stated for the record, Your Honor, we may not need to spend a lot of time on this. My question, Mr. Akiki, is not about the substance of the variation order. My question is not whether you were forced to sign it, whether Reem should have asked for it earlier, none of that. This is not my question. My question is simple. Do we agree that the date of the variation order is 30th of July?
Yes, it is 30 of July 2019.
And do we agree that the works required were the reinstallation of 150 panels of balustrade glass that had been damaged?
Have been damaged, sorry? Yes.
Yes. Do
Yes.
we agree that there was that you agreed the cost at 132,000 dirhams and change? That this was the agreed amount?
Yes.
Okay. Do you factor in, did you factor, I know the answer, I think we know the answer, but for whatever it's worth, did you factor in, did you consider in your delay analysis that a variation order was issued in August?
Of course not.
Of course not. Now, and one last question on this. When were these glasses delivered? Were they delivered before or after the hotel opened?
I think majority they were after. I'm not recalling if there are some items of them they came earlier than the opening, but most of them, majority of them, they were after the hotel opens.
When, if we have the time to deal with this variation in detail, you will see messages that you have exchanged with Mr. Ahmadi on the 2nd of September.
Yeah.
Was the date of the hotel opening, which showed that they were not delivered, none of it was delivered. All
Okay.
150 glasses were delivered after.
Then
I think we can, please take my word for it.
Yeah, thank you.
Where was the hotel opening delayed because these glasses, because these glasses were not on site?
We could not operate part of the, I mean, whatever is 150 glass, wherever they are installed, we could not use, we could not even offer these for the clients who have bought the apartments, because some of them residential. So yes, the hotel was not fully operational after the 2nd of September because of the missing glasses, correct?
So let me rephrase, because I asked a question and I would like the answer to my question, and I will add what you said. No, yes. The hotel, it was not prevented. It did not prevent the opening of the hotel, but we could not perhaps rent all of the rooms. This is what you're saying.
Yes, but there is one more thing. Not only the rooms, because here I need to explain. There are some hotel rooms, which is correct, my answer. But also there are residential apartments. This is what I said. We could not hand over the residential apartments to their purchasers due to the missing glass.
Right. I will not go into, if we have the time later on, we will discuss.
Sure.
What was the damage? But for now, I think I had my answer. Let's move to another issue because we are I am reminded, Your Honor, that we reached the break point.
It depends on your questioning. Do you have a short point, or how much longer do you have, do you think?
I will need some time more, Mr. Ahmadi, I'm afraid. So it's not, I'm not going to finish within the next 5 minutes. This is what you're asking, Your Honor.
We'll have a break now then. How long do you want?
How much does Mr. Al-Mahdi you want? I mean,
Mr. Akiki, how long would you like?
I'm very flexible. I'm very comfortable. Please, you decide, my lord.
Let's have 10 minutes then.
Thank you.
Yeah, we'll resume at 9:40. It's 12:40.
Use your warning as well, please, my lord.
Yes, and remember, Mr. Akiki, not to talk about the case with anyone in the meantime.
Understood.
Thank you.
Confirmed. Thank you.
Thank you.
Thank you. Yes, well, if we're all back now, Mr. Kavelis, it's up to you to resume.
Thank you, and we will expedite, Your Honor. Let me discuss with you another issue, Mr. Agiki. At paragraph 5 of Mr. Al-Mahdi's first witness statement, I will not show it, I will read it for you. He made the following statement. Upon joining Reem, I worked on the project to install the aluminium and glazing works at the 5 Palm Jumeirah project, a luxury 5-star hotel complex in Dubai. On that project, I was also Reem's project manager, and these works were successfully completed by Reem in 2016. Now, you responded to this comment in your reply witness statement, your second witness statement. And it was a little bit odd. Mr. Ahmadi made a passing comment just to give context, which was 4 lines long. That was the paragraph. Your response to this was probably the longest paragraph in your entire witness statements, 24 lines. I counted for them. It was 24 lines in your reply witness statement. It is paragraph 6 of your second witness statement. It's page echo 1783, Your Honor.
Thank you.
And there you made many allegations of Reem failing to perform works in accordance with the designs and specifications, failing to provide proper acoustic and weather insulation, and you say that Reem used cheap quality materials. You further allege Reem of having caused 5 to suffer severe damages due to Reem's alleged, and that's your words, deviation from this project specifications and drawings in their executed works. Do you recall, do you wish to read again paragraph 6?
I fully confirm this, and I recall it very clearly.
So because you were also the project manager, well, you were in charge of 5 for the 5 Palm Hotel also. Am I correct?
I was the CEO of 5 Development. That's correct.
Right. So you suffered severe damages.
Yes.
As a result of failure to comply with the contract requirements.
Yes.
What is the claim that you made against Reem?
Exactly. Here, I need my time to explain exactly what happened in that project, if you allow me, my lord, because the 24 lines that you mentioned, I was very concise, not to waste the time of the court reading more about another project, another experience with Reem. But since you opened the question, I would like to clarify the background and the damages and all what happened there.
Before you do that, I
Yes,
just want to ask Mr. Karvelis, is this a matter we're going to spend a long time over? Because it can't affect my judgment in this case, can it?
Not entirely, but it is direct to the credibility of Mr. Akiki. And actually, my question was very simple. How much was the claim they made?
Yes.
Simple answer. 100, 1 million, 1 billion,
Yes.
0.
I did not have a direct contract with Reem in the Palm. My contract was with China State, and they were subcontractor to China State. We definitely claim a lot from China State because I don't have a direct channel, and I believe this was one of the major. Sorry, can I continue? Can I continue? And this, in my opinion, since you are questioning my credibility about this point, I am questioning also the credibility of Reem, because we really have reports from third parties confirming that they have used quality which is not acceptable by any standard, and they have admitted this and they have changed them, and this led to infiltration. Yeah, sorry.
So I'm going to stop this on both sides, because otherwise we have 5 days of litigation about a different project where there's no claim.
Agreed.
No direct claim. Mr. Carvelis, if there's a short point, fine. If it leads into a discussion about a different project, I think I'm going to have to stop it.
I will not ask further questions about that project, Your Honor, although I reserve to make certain points in the closing submissions.
Right.
Unfortunately, I will not have the pleasure of discussing them with Mr. Akiki, so you will have to take our words for it. But what is relevant is the basis on which they hired Reem for the new project which we have in dispute. What did they know at the time they hired Reem? Is this not relevant?
That may be relevant if you can confine your questions so that we don't go into the whole history of another project.
So you say, Mr. Akiki, that that was a breach of specifications. Your complaints were breach of specifications and all that stuff. This is what you say. That's what Reem did wrong in the previous project, right?
Correct.
Okay. Let's see now. You sent a letter of intent to Reem in mid-2015.
The letter of intent, it was 4th of July 2015. That's correct.
Okay. Summer of 2015. Did you know about the terrible work that Reem did at 5 Palm at that time? It's a yes or no. You did not.
No. Because I'll explain why. Because the other hotel opened on the 31st of March 2017. So between this and that, there are 2 years, and we discover much more later the problems that they have caused.
Okay, excellent. So you did not know when you issued the works order, right? When you issued the works order in April 2016, you did not know about the issue.
2015 we issued, not 2016.
I'm talking about the works order now, which was issued in April 2016, a year after, almost.
Sorry, I did not understand, Mr. Carvelis.
A year after, you issued a letter of intent in 2015. In April 2016, you issued a works order.
Yes.
To Reem, by means of which Reem started works. So
correct.
You are saying that in April 2016, you still did not know?
No, we did not know, because it's related to the final infiltration of the facade, which caused a lot of problems for the finishes. So at that time, we did not know yet. Correct.
Excellent. And you did not know, and then we had the fire incident, correct?
Yes.
And this was in August 2016.
6th of August 2016, correct.
Okay. And then for 11 months, you say that everything froze. Nothing, no one worked. There was no work on site. Right?
Yes, that's correct.
Yes. So, and this takes us to the summer of 2017. August 2016 plus 11 months makes July 2017.
Yeah, here I need to clarify one thing. If you
Before you clarify, just answer my questions. I told you at the end, you can clarify whatever you want, but for now, answer my questions, please.
What is your question, please? Can you say it again?
So you say that for 11 months, from August 16 to July 17, no work happened.
No,
right?
the work happened. There are a lot of work happened, and including these works, there were the rectification of the fire and the concrete, and there are some other areas where some minor work happened.
This is not a question in relation to what works happened. I'm just asking. I think it's a simple question.
Yes.
We have 11 months where you say that there were not many works happening in JVC, right? Yes? Yes. Did you know in July 2017 that Reem had caused so terrible, severe damages?
By July 2017, yes, it became I mean, known for us that there are major problems there.
Okay. And in July 17, I think we can agree, there was no contract in place for him other than the works order. It was only the works order. There was no contract with China State and no contract with FIRE. Do we agree on this? In July 2017.
We have work order in April 2017. Yes.
So we have the work order. And,
yes.
And we have a contract signed with Reem in June 2018, a year after. Do we agree on this?
What is the date? Can you please repeat? 2019, you said?
Beginning of June, 4th of June, 2018. Do we agree on this?
Yes, that's correct.
Another year after. And by that time, I guess, not only you knew
yes,
the extent of the damages, you had already commenced proceedings against the main contractor, China State.
Yes, that's
correct. Am I correct?
That's correct.
Okay. So, but until June 2018, you did not terminate Reem, did you?
No, I did not terminate Reem.
Let's move to the next subject then.
Are you interested to know why or not relevant? As you wish.
Not relevant, indeed.
Not relevant, okay. It can be left for the examination necessary.
Let's please move on to page E376 of the bundle, which is your second witness statement. It's paragraph 15.
Paragraph what? 15?
Yes, 1-5.
Thank you.
If you have your witness statement with you, Mr. Akiki, I suggest you, if you have a hard copy, you can look at the hard copy so that we don't show it on screen as you wish.
I'm really sorry. I don't have any document with me because I'm traveling. If you can share it on the screen, I would appreciate that.
Okay. Although I will read the passage that I need to discuss with you.
Yeah.
Right. You say it's halfway down this long paragraph. I further note that at the time of the 3 May 2017 meeting, this is, first of all, to give context, this is where you explain about the fire incident, which took place on the 6th of August.
Yes.
And you explained that there were extensive negotiations between everyone involved, basically, to find out, as it's obvious, to sort out what is going to happen. And then there was a particular meeting on 3rd of May, and you exhibit the minutes of meeting, you make reference, and then you go on to say that as part, I further note, it's a little bit further down, after your reference to ring delays to be cut within a week. We'll get back to that later. You say that I further note that at the time of the 3 May 2017 meeting, the estimated structural delays were 11 months, and you take us to item 9 of these minutes of meetings. None of the subcontractors have had any activity to do or works to perform during the 11 months period. This also meant that the defendant was not incurring any costs because there was no presence on site for 11 months and there was no requirement of the defendant to do any work. Is this the exact language in your witness statement?
Yes, that's
Yes.
that's the language. Yes.
Can you please direct me, can you show me the copy of the suspension notice that you issued or the engineer perhaps issued following the fire incident?
Substantial note, it was already given during the weekly meetings, which, and I think there is one meeting, it took place 1 or 2 days after the fire. I don't recall the date. And
Can you show it to me? Can you
Can
show it to me? Can you show me this suspension notice? First of all, okay, let me be fair with you. Let me be fair with you.
Yes, please.
Do you understand what suspension notice means in a FIDIC contract? Are you aware what is the definition of a suspension notice in a FIDIC contract?
Yes, definitely I know.
You know, okay. So it is a notice which is called suspension, headed suspension, it's a letter.
Yeah.
It makes reference to the relevant clauses of the contract that permit suspension, details the cause of the suspension, and the estimated period of suspension. So it's a letter. And this letter is sent usually by the engineer to all contractors. And sometimes, if the engineer is not very diligent, I have seen employers sending such letter. Not minutes of meeting, letter. Did you ever send such a suspension notice?
No, there is no suspension letter with the way how you are describing it.
Okay, thank you. Now, in your second witness statement, the same one, you point to a record noted in the minutes of meeting dated 3 May. I just read it to you. That states, Reem delays to be cut, you mean caught up within a week time. You see this, it's a few lines above in this paragraph 15 of your witness statement. And I have this question. You say that the works were suspended effectively. That's what you're saying. So how is it physically possible? Physically, how could Reem being delayed in May 2017 when works were suspended from 6th of August 2016 to July 2017, during the suspension, we agree there are no works. If there are no works, there's no delay. Or at least, how could Reem possibly remedy such delays in a week's time when the works were suspended at that time. How is it physically possible if the works were suspended? It's either the works are suspended or it was delayed.
Yeah.
Which of them? Were the works suspended?
Yes, above the levels.
Yes. Okay. Let me follow on.
Can I finish
my question?
Can I finish?
Mr. Carvelis, let him finish his answer, please, Mr. Carvelis.
The building is 60 floors. Thank you, my lord. The building is 60 floors, and the fire took place at level 17 and 18. So we had to remove the entire structure of 2 floors, including the columns, which are slightly below on the 3rd floor. And also the fire came down to level 6 because the podium level is bigger. So the suspension is 100% sure from these levels and above. So the building was trimmed at that level. So there is no physical possibility for any contractor, including the concrete contractor, to move ahead. So that work was fully suspended. However, there are minor works that took place in the basement, which are very minor. Some places where in the lower level where possible. This is where I agree that there are some works that they have been done by Reem in the lower levels, but not the suspension, which is the major part of the building. So just to clarify why I said physically is not possible, because there is no structure to put anything on it. And for 11 months, then we got the NOC from the authorities to start again and to move ahead.
So we just encountered the 3rd instance where what you say,
yes,
we just encountered the 3rd instance where you write.
Yes.
What we understand that you write is different than what you meant, because I will read again.
I agree with you. I agree with you.
Excellent. Let's move on. Let's move on now to F2019.
Yes.
I think we will agree that this is an email from Mr. Ismail Magor, dated 5th December 2016, to Faisal, which I believe Faisal is a 5 staff.
Yes, correct.
And this email clearly suggests that we can see on screen. Sorry. Yes. It's very. In my reading of this email is that this email suggests that on that day, actually the day before, 5 December. No, that day, 5 December, works had resumed and Reem was on site. So I think we can agree, this confirms, if you like, what you said earlier, that it's not that all works were suspended for 11 months, some works were suspended 11 months.
I agree with you. That's correct.
Suspended or delayed, out of curiosity. How do you understand the word suspension? Suspended or delayed?
Yes, any work related to the building from the levels that they have been affected and above has been suspended fully for 11 months. And there are some
minor done.
100%, because it's in the air. It's not possible physically. And this is exactly what I meant. Now, in the lower levels, there are some minor works, whatever we could keep going. Also, the contractors, they were trying their best to keep going wherever they can. But they were, again, very, very minor compared to the overall work of the building.
Then let's move now to page E1784, which is, let's look particularly at paragraph 7 of your 3rd witness statement.
Yeah.
You say that. You say here, I would like to point out that Salim Ahmadi, the project manager, states that he was not available to manage and oversee the works on the project for the period from March 2017 to March 2018. You see this?
Yeah, I can
This
see that.
absence is evidence that following the fire incident that occurred, the defendant not just deployed Salim Ahmadi elsewhere, but also its other employees on other projects which were undertaken by the defendant during this time. These are your words again, correct?
Yes. I do confirm.
Okay.
What paragraph is that?
This is paragraph 7, page
7.
echo. Yes, paragraph page E, echo 1784 of the bundle, Your Honor.
Yeah, I have it. Thank you.
Now, can we agree that March 2017 is 7 months after the fire incident?
March, yes, from August 6 to March, yeah.
Can we also agree that March 17 is a period of 4 months after the works had resumed, as we just saw, in beginning of December?
Yeah, that's
We
correct.
can agree. Are you aware, do you know who Mr. Ahmad Daraz is?
Yes, he was a project manager from Reem.
So he was the one who replaced Mr. Ahmadi on this project during the period of March 17 to March 18. Am I correct?
I don't believe that he replaced Salim because Mr. Daraz, he was continuously there from the beginning till the end. And I believe in that period, Reem minimized the number of the staff. This is how I understand it, not the way how you describe it.
Well, your counsel will not be very happy with your answer, considering the questions that he asked to Mr. Ahmadi about Mr. Daraz, but I'm sure he will deal with it in his re-examination. Now, you say that as a result of the, because of the fire incident, your words are that the defendant deployed staff elsewhere. So it's a simple question. How Mr. Ahmadi's absence from the site during a period that he was replaced by someone else, by Mr. Daraz, is in any way evidence that the defendant deployed staff elsewhere because of the fire incident. This is your testimony. Because there was the fire, they took their staff and they moved them somewhere else.
Yes, that's correct.
How? How is this possible? Anyway, let me move on.
It is possible because I witnessed it. I have seen on site that the number of people before the fire incident and the number of people after the 11 months of delay is totally different than during the period from 6th of August till March. That's why
yes, but the thing is, Mr. Akiki,
yes,
in what very often becomes a very detailed witness statement, in this instance here, you make reference to 2 persons only. Mr. Nair, Haris Nair, who we established that he was there from day 1 to day Z, to the last day, and Mr. Ahmadi, which we agreed that he was replaced by Mr. Daraz for the period that he was there. These are the 2 persons that you mentioned in your witness statement. No one else.
I'm not supposed to be the timesheet of Reem. They should prove how many people they are on site and how many not. I mean, I'm sorry, it's not my job to count
Excellent.
How many staff they have, but this is my witness. This is what I wrote, and I fully believe in this. Yeah.
Okay, excellent. You believe that these 2 persons were all that it was. Let's move on.
No,
you wrote a paragraph.
No, that's not what I said. I'm sorry. I don't believe this is, you are putting words in my mouth, which I will never accept. because you are now telling me that I said these are the only two that they have been moved. It's not correct. I'm saying I witnessed these two because I have been interacting with them. They are at the top management level. However, the staff has been removed. I mean, majority of the staff have been removed because I have seen that the numbers are less. But now, who has to prove how many people they are on site is Reem, is not me.
It's a legal question. I'm not sure your counsel would agree entirely, but anyway. And we'll see about it.
Sure.
Now, you wrote at paragraph 16 of the same written statement that you accept that the fire incident had consequences on the main contractor's works. You say that, your witness statement. I assume it's self-evident, right?
Yes.
Would you accept that it would also have an effect on Reem's works?
Of course, 100%.
Of course. Okay. Now, I have this issue now here.
Yes.
You have a delay analysis, what we call anyway, a delay analysis, which
Yes.
has nothing, which reflects nothing that actually happened on site after 15 March 2019. It just ignores as if they never happened, if it is meant to be a delay analysis. And you have now your acknowledgement at last that when you said that 11 months, nothing, it was a dead, empty site, that's not exactly what it was meant to be, what you meant, but some works were happening, some works were not happening, not explained, you don't explain when exactly works commenced in the blocked floors. It's not a question, it's a finding, Mr. Akiki. Once again, you prove unreliable. And let's move contract negotiations and clause 4.5. I'm sure you are eager for this.
Which one I agree? I'm not sure on what you are thinking I'm agreeing. I'm really sorry.
It does not matter.
Yeah, exactly.
Really.
Mr. Ellis, you can't say things and then not allow the witness to deal with them. It's not an opportunity to make statements. If you say something, it must be interpreted as a question, and the witness must be allowed to answer it. Right, Mr.
I thought it was, Your Honor. I can rephrase if it was not clear enough. Happy to rephrase.
You haven't allowed the witness to answer it. You just said, let's move on. Mr. Akiki, do you want to deal with what Mr. Carvelis said?
I'm happy to deal with anything that he said if it's clear, but please clarify what you want to ask me, and I'm happy to answer, Mr. Carvelis.
Thank you.
Thank you.
Can I move on now, Your Honor?
If you want to repeat, unless you are asking a question, I'm not taking a note of it. So, are you asking a question to Mr.
I will ask the question. Were the works suspended for 11 months, as you say in your witness statement? Yes or no?
You answer this, that the majority of the work has been suspended, minority of work has been ongoing, and I answered this clearly maybe 10 minutes ago, and I'm happy to answer it again.
And we agree that you don't make this distinction in your witness statement.
Yes, it was not clear enough to understand it the way how I'm describing it now. That's correct.
Okay. And we agree that your delay analysis ignores everything that happened after 15th March.
No, this part I did not understand, and I disagree. Can you please tell me exactly here? This is where I felt there is something which I'm not able to catch. Can you please clarify that part to me?
Yes, it will be. I'm sure if you stay to watch the discussions with the experts, you will understand. A delay analysis is a scientific exercise,
yes,
which it is supposed to depict actual situation
yes,
from the start, from the first day of the works until the last day of the works. A delay analysis is reliable and can be not even reliable, can be the basis of a discussion to check the reliability once it is established that it shows every significant event that affected the project. It can start becoming a basis for discussion if it identifies a critical path from day one to day last, and if and where delay analysis. It can take various forms and it can apply many different methods. There is not just one method for a delay analysis, but an analysis which does not depict reality, and it is an assumed projection to the future. It can be called many things, but not a delay analysis. I gave you the benefit on Monday. I asked you, do you want me to treat it as a delay analysis in the scientific term of the word, or as your own assessment of delays based on your experience and your understanding of the matter? Regardless of your answer was a delay analysis. I will not treat it as a delay analysis because it won't take us anywhere. It's not a delay analysis. In all, however you look at it, it's not. So now that I explained, and unless Your Honor, there's something else that we can discuss on this, can I move on to the next issue?
I don't know whether that was a question. The trouble is, if you're making it a submission, leave it till the end. If you're asking a question, then I think Mr. Kiki must be able to answer it. So I think he must be allowed to comment on what you just said.
Yes.
Right, Mr. Kiki.
That's what I said, Mr. X.
Mr. Kiki.
Yes, thank you, Your Honor. My delay analysis is based on the facts and based on my witnessing of what happened on site. And it is not true what you are saying, that I did not take into consideration the delay that the fire has caused. The delay has caused, the fire has caused delay, which Reem are not responsible of. And beyond that, let me be more clear. Okay, now after then we have the NOC to start the concrete. We have in the addendum number 1 that we signed with the main contractor, we have a new date for the concrete to finish. And these new dates also, they were not respected by the main contractor. And there are, if I remember, 4 or 5 months of delay. So all these are not the responsibility of Reem. And Reem, they are entitled, I'm saying it clearly and in front of Your Honor, that they are entitled to claim for extension of time during the fire caused by the fire delay. So that's something that we are not, and that's why I accepted to put 4.5, the clause 4.5 in the subcontract agreement, which is recognizing the right of Reem to claim for the extension of time caused by the fire. So based on all of these facts, I disagree with you that my delay analysis did not take into consideration the delay that has been caused by the fire, which is not the responsibility of Reem. I just finished my comment on this, Your Honor.
Okay. Shall we move on then?
Thank you. I think I was clear. My criticism was primarily for delays after 15 March 2019, not the fire incident. I never made any comment about the fire incident. I rely on your testimony that there is no liability for Reem prior to 15th of March.
Yes.
Just to clarify. Now, let's see about 4.5. We have, what time is the scheduled break, Your Honor, if I may?
11 o'clock, another three quarters of an hour.
Okay, all right, thank you.
Or an hour, it depends how you get on.
We might, depends, it will depend. I think I will skip a few, and but this is something that I think we should discuss. I'd like to understand, Mr. Akiki, now the negotiations between Reem and Five.
Yes.
Let's see F23 of the bundle, please. This is the works order, the work order. This was issued by Five to Reem on 19th of April 2016. I think we can agree on that.
Yes, that's correct.
And I think we can agree that given that there was no contract between Reem and China State, this work order remained the contractual basis upon which the defendant Reem carried out the works until June, when the subcontract was actually signed.
Yes, the work order, including the letter of intent. That's correct.
Yes, and the price agreed is 47 million.
Yes,
The work order.
that's correct.
Okay, and it was based on the assumption that Reem would complete the works by 8th of November 2017, right? When the works order was issued.
The work order, if I'm not mistaken, I'm really sorry, it's not clear in my mind, but if I remember, it referred to the addendum number 1, completion and schedule, that has been signed between us and the main contractor. So it has the same back-to-back completion date, if I'm not mistaken.
I think you are mistaken, because this is what you refer to is the contract, the subcontract, not the work order. The work order was in April 2016.
Yes.
It was the original completion date.
Yes. Then so, it was 8/12/2017. 8/12/2017. Yeah. Okay.
So Reem agreed to do a certain scope, 47 million.
Yes.
And this scope would need to be completed 8th November or December 2017.
Yes.
Do we agree on that?
Yes, we do.
Of course, we know that this did not happen. The hotel, the works did not finish. The hotel opened on 2nd of September 2019.
Yes,
right?
That's correct.
And we agree. I guess we may disagree as to what caused it, but I think we agree that that Reem was still on site canning works until October
2019. Yes, that's correct.
Yes. We disagree. Why? But it is a matter of fact.
Yes, yes.
Now, in your experience, I'm sure you agree that if a project is being delayed, this has a cost implication.
Yes, I do agree.
Of course. So when you commenced negotiations for the subcontract in September 2017, I think we agreed thereabouts.
Yeah.
Negotiations started in September. At the time, no doubt you were not surprised. There was a claim, incidentally, 4.5 million for delays. I don't think it came as a surprise, did it?
It was never a surprise, no.
And obviously, I mean, you would do the same. Reem would try to protect their interests for this delay that they had suffered until that time. That makes sense, right?
Absolutely.
Okay. Now, in April 2018, we are now in April 2018, a few months after. The negotiations now for the subcontract are in a climax. They have a lot of negotiations, trying to agree the actual terms. Did Five withhold payments due to Reem at the time? In April.
Sorry, can you?
2018. April 2018.
Okay.
The last time, the last period just before the signing of the subcontract. Were you withholding payments?
The payments, we were trying to pay as much as possible in the absence of bank advance payment guarantee and performance bond guarantee. As you know, the authorities in Dubai are very strict with the Dubai Land Department regulations. So we have an escrow account, which is from the escrow account we have to pay the contractors, and without advance payment guarantee and performance bond, it is almost impossible to pay them. But we were doing our best, and we explained to them several times that in the absence of this, we can't be responsible for the payment if they don't reach you on time, because there is no performance bond and advance payment guarantee and contract signed.
That's okay.
It's a matter for the quantum experts, by the way, and it will be discussed during the quantum experts. You offered some interesting points here.
Yes.
But the point remains, a sum that was due in April 2016, which was 4.7 million, and another sum of 5 million. This 4.7, by the way, was the balance of the advance payment. Some of the advance payment was made.
Yes.
Some was not made. 4.7 million, and another 5 million, which were certified payments. It's not advance payment anymore, it's certified payments. They were unpaid in April 2018. Do you agree with this? On a numbers as numbers basis.
Okay, what I remember is the following. There are correspondence, even if I believe in front of the court, there are correspondence saying for Reem, so to expedite the bank guarantees and signing the subcontract agreement so we can pay. And immediately when we receive the bank guarantees, we pay a big portion, which was valid to be paid that time. Now, if there is another portion that you are mentioning, it was not paid. I don't recall this, but we can check the accounts are clear.
Well, it's 4.7, the balance of the advance payment, and 5 million certified payments, higher, more than the balance of the advance payment. Okay. I guess my question is, were you withholding payments in order to try and force Reem to accept your terms of the subcontract?
No, never. This was not the intention. The other way around. Reem, they were delaying work and they were reducing number of people in order to put the terms, which is 4.5, to insert that clause in the subcontract agreement. So it's the other way around.
Let's see if it's the other way around. Let's look at the document G919.
Yes.
So
now, your honor, is G919. 919.
Yeah, I didn't get the letter there. What letter was it?
Golf. G, golf.
Okay.
Now, this is a letter sent by Salim Al-Mahdi to the engineer. You see this, right?
Yes.
Okay. Mr. Al-Mahdi says in this letter, look at the third paragraph. Reem, correct? Ria means Reem, right?
Yes, that's correct.
Do not think that any such contract signature should be held as a reason of non-payment of their extremely delayed accounts, which are pending for over 6 months now. These include the last part of the advance payments as well. Do you see this?
I can see this.
Okay, so do you agree now that Reem's position was that you were trying to force them, you were using payments due as a means to force them to sign?
Absolutely not, sir. And I explain. I still see it the other way around. Because what this letter is saying, that Reem do not believe that delaying signature of the contract. So it means they know that the signature is being delayed. They are saying, even if we delay the signature, please pay me. This is what is this letter saying, sir. So it's totally the other way around. They are not saying that you are delaying us or the client is, or 5 is delaying us. They are saying, we don't believe that delaying the signature, which they are delaying the signature because they want to put the clause that they want. They are saying, please pay us even in the absence of the signature. But the problem is not my intention to pay or not. The problem is the bank guarantees, absence of the bank guarantees too, advance payment and performance bond. If we don't have them, even if I want to pay them, I cannot pay them.
So you did not pay the certified payments of 5 million because there was no performance bond, or because they were delayed and they had less. You said earlier that it was because they had less people on site. What was the reason?
Yes, I mean, you are talking about one payment, but there are other payments. In other contexts, sometimes if they delay and if they don't recover, we also do delay the payment. That's something, it's a different context, but we are talking now about this particular letter. We are talking about signing the subcontract agreement and paying them. So that context is different than the other context.
So let me understand. We have a contract of 47 million, right?
47 million.
47 million.
Yes.
And we are at the initial stage still, right? Because we had the work started in April, May 2016, but then we had the fire. And you say that the majority of the work stopped for a year almost, right? And then they resumed in sometime, we know that they resumed in December. 5 million is a little bit more than 10%, right?
Yes.
Of the 47. So we have certified payments.
Yes.
Works executed.
Yes.
Works executed.
Yes.
More than 10% of the contract price.
Yeah.
And you were withholding them. Why?
Why? Because the letter of intent called them to enter into a contract with the with the main contractor 2 weeks. Yeah. So they are the only subcontractor. So if we don't use this, please, I mean, because we will annoy everyone in there. So let me just finish, and then you will say your comments if you don't mind. So if they were the only subcontractor that they did not enter into a subcontract agreement with the main contractor for more than a year and a half. Okay. So that's why I was obliged to go with a work order, which is an exception. Usually we don't make work orders in the presence of the main contractor, but as an assistance to Reem to resolve whatever they want to resolve with the terms and conditions between them and China State. So we did the work order. And now after the work order, I try to pay as much as I can, which the authorities, they allow me to pay to them in the absence of the guarantees and the subcontract agreement. So that's the full story. Not more, not less. If you want to understand why this subcontract has been delayed, this is the reason. It's not me. I was pushing from the beginning for this to happen, and I was very happy for this to happen.
So we have a third explanation now why you did not pay certified payments for works executed. First, you told us the advance payment, the performance bond. They did not provide. Which is, I submit to you, only relevant for the advance payment guarantee if it is. It does not apply to works executed, payment certified for works executed. Anyway, in your own explanation is, A, there was no advance payment. Then, no, we did not pay them because they had not sufficient, they were delayed and they did not have had sufficient labor on site. And now we have a third explanation, which is because they did not sign the subcontract with China State. is this not, did you not give these three explanations? Am I wrong?
No, you're mixing things together, sir. Let me explain. The signing the subcontract is exactly the same thing like having the bank guarantees or not bank guarantees without subcontract agreement. So these are two in one thing. If I want to put it this way, that's one basket. There is another basket which is related to the delay of the work. That's which I call it previously another context. So there are two contexts of the payments. One is related to the bank guarantees and the subcontract being signed. So these are two in one. These are not two different reasons. And in the other context is delays, which entitle the client as per the FIDIC and as per the contract. If there is a delay caused by the subcontractor, the client has the right to delay payments.
All right, okay. Very interesting all that. Can I see, please, can we go now to F2030?
Yes.
What bundle was it? 203. F.
F2030.
Yeah.
Okay, if we can. This is a message that you sent,
Yes.
right? To whom, by the way? Is it to Salim? I will take, I put to you, it is to Salim. And don't move up, just leave it to the.
Yeah.
It is to Salim. It's
Yes.
okay.
This is
Okay. Let's see what you say to Salim. Let's see it on screen.
sorry, I did not understand what you're saying, sir.
Give me a second. Give me a second.
Okay.
Can we go to 2030? Yes, there. You say now, Vimal, I guess it's someone of your employees, will send the final shortly. Please sign today. Am I right to assume that this is the subcontract?
It seems so. I can do it.
Okay.
Yeah.
And return, so I can pay you today itself, whatever this means.
Yeah.
And tomorrow, please deploy full manpower.
Yes.
So we can agree that A, the bank guarantees had nothing to do with payment of certified amounts. It's not mentioned there.
It's not correct. But if
Thank
it's
you.
not meant, this doesn't mean it's not. It's not.
And the two conditions which you made clear
Mhm.
that are dependent on the payments that you control would be sign the subcontract and you make a plea to them to deploy full manpower from tomorrow.
Yes, that's correct.
Yes. That's what I wanted. Let's see now. Let's see page G1293. Can we go back after I go to the next topic, because I'm afraid that I will lose the time that I want. Your Honor, can I have 1 minute, please?
Of course, yes.
Right. Now, I think we agree that the subcontract was signed on the 4th of June, right?
The subcontract?
Yes.
4th of June, June or July. It was, there is a confusion. It was the, I think, I don't know. If it's June or July, I'm not sure.
For June 2018, take my word for it, please. I will be corrected if I'm wrong.
I trust you.
Okay. My point, Mr. Akiki, is that the subcontract was signed on the 4th of June and not earlier, and not on any other day, for a very specific reason.
Yes.
There was a reason that you agreed to sign this on the 4th of June. At 8:01 in the morning on the 4th of June, you sent a message to Salim on that day.
Yes.
That we should, and the message was that we should resolve the contract today.
Yes, that's correct.
Okay, that's, you see, it's 8 o'clock in the morning.
Yes.
At 4:03 on that day, Salim sent you an email wherein he relayed to you that a third and final management discount with regards to the fire incident prolongation costs, it is G1293, Your Honor, as you can see, were now reduced to 3.5 million. Do you recall this email?
I don't recall it, but I do not deny it if it's an email.
This meant now a total liability of 4.6 million if we add the 3.5 approximately for prolongation costs and the 1.1 for materials and tools claim resulting from the fire.
Yes.
You can see this, I guess. So the total amount Reem was seeking to be paid pursuant to clause what was clause 4.5 was now 4.5 million, 4.6. Do we agree so far?
Yes, that's the email.
So from that moment, 10:03 in the morning, you knew that all China State had to pay to Reem was 4.6 million, not anymore the additional discount of 1 million, not anymore the 9 million prolongation costs. It was now total 4.5, which you said it yourself, you expected that Reem would have claims for this. Okay. And you knew that if China State did not pay, then as a result of clause 0.5, you would be responsible. But you knew now that your exposure was reduced at 4.6. Am I right?
No.
At 10:03 in the morning, you knew what was the maximum, your maximum exposure.
No,
am I wrong?
No, it's not correct. Here, I would like to correct you. I'm sorry to say that, but the way how you are positioning it, that this is an exposure for us, for me as 5, and this is a liability of 5, and you know that you have to. That's not accurate. What is accurate is the following. I never had any problem with any amount that Reem may claim from China State, and I was encouraging them to get and to engage with China State for a long time, okay, and to claim, because finally there is a CAR insurance for China State, and even China State, they have admitted that they will compensate Reem for any amount which is reasonable, and of course it should be approved by the insurance company and so on. So to say that I know that this is my liability to pay them, this is not correct, because the clause 4.5 is very clear. It is defining whose liability is to pay Reem, which is China state. And in case they will fail to manage the claim with the insurance company, even the clause is very clear. So I'm sorry to correct you that it is not my liability to pay them. It is China state liability to pay them.
Let's go now to F2027.
Yes.
Just the NASA.
Can we open it?
It's a, oh, sorry.
I can't see it on screen. Who is Nasser Al-Marzouki?
Nasser,
Mr.
sorry, is the question to me?
Yes, who is Nasser Al-Marzouki?
I believe he's a CEO or a manager in Reem. I don't know exactly the position, but he's a senior person who is representing Reem.
Okay. Indeed, he is, by the way. I can confirm that. Indeed, that's what he is. He is your opposite number, if you like, at Reem.
Okay, thank you.
Now, at 10:34, you sent a message.
Yes.
To Mr. Nasser Al-Marzouki, agreeing to clause 4.5 of the contract, stating to him the below text, if you read, the below text is 4.5. You see this?
Yes.
When you start the message by saying the below text, you copy-paste it 4.5, and you say, is the maximum I can do for you on a very special case that you never do for others. You confirm that you asked China state to sign as a third party to witness it, but they refused.
Correct.
I have no option to take the risk on their behalf and secure your risks reasonably.
Correct.
So you confirm basically if China state does not pay, you will pay.
I confirm what is the content of the clause 4.5. Please, let's don't interpret it. Let's read it, and then we can discuss.
Do you want to press him more on this or move on?
Please, please, feel free.
No, I will not. I will come back to this later.
Feel free. This is the word. Feel free, please.
And we will have. Can I have 4.5 on screen, please? Let's not beat around the bush. 4.8. Let's look at the contract, please. Not this. Your Honor, the contract is. Can we find the contract? Apologies for this, Your Honor.
That's all right.
Ready?
No, it's just abstract.
Huh? Is it not in one of the witness statements?
No.
Maybe I can help my learned friend. What is it my learned friend is looking for?
Yes, if we look, yes, it is, yeah, thanks, Martin. I think it's in paragraph. No.
Tell me what you're looking for. and I'll-
Yes, for the subcontract, the nominated subcontract. I found the passage that I wanted.
Okay.
It's in Mr. Akiki's second witness statement, page 24, paragraph 24. We can have a look at it there.
Sorry, here it is.
We found it, sorry.
Where is it?
Okay, it's in E45,
E460.
E460. It starts at E460. The relevant part is in E461. Okay, let's make it bigger, please. Oh, thank you. Okay, right. Now, what does it say? Additionally, the interesting part, I think we can agree that the interesting part starts from additionally. The main contractor has accepted the liability tolls claims raised by the subcontractor, China State and Reem, on the fire incident of 6th August, as referred to in the letter dated 27th May. It was extensively discussed yesterday. It is the letter from China State to Reem, which forms part of the agreement. However, not limiting the claim to the car policy. So, regardless of whether, that's how I read it. And if you disagree, let me know. The contractor's all risk policy covers or not, pays or not, the insurance pay or not. The main contractor should additionally pay all reasonable costs of prolongation claim made by the subcontractor. Do we agree so far, Mr. Agiki?
We are reading correctly, correct.
Okay. Substantiated and approved by the engineer and the employer, Atkins and 5, correct?
Correct.
Which shall be settled within a reasonable period before closing the subcontract's account. Do we agree so far? So substantiation would have to be made to Atkins and 5, and the claims would have to be approved by Atkins and 5. That's what the contract says, correct?
That's correct.
Okay. And if the main contractor does not is in breach of this obligation, that's what it says furthermore.
Yeah.
If you go further down,
Yes.
then the employer shall deduct and pay to the subcontractor. And the employer is
Sorry, maybe you skipped one sentence, sir. If you don't mind, can we read that?
I shall deduct such reasonable and approved amount from the main contractor. 5 shall deduct from China State and pay to Reem.
Yeah, that's correct.
Okay, I read it correctly.
Yeah, the second time, yes, correct.
And we agree that the substantiation and approval of this prolongation claim would have to be by Atkins and 5. Correct?
That's correct.
No further questions on 4.5, Your Honor. And I can move on to the next issue. Unless, of course, Your Honor, there's anything that is not clear.
You carry on. Carry on, Mr. Caveres.
Okay.
But tell me this: how long do you think you're likely to be for further in cross-examination? Just thinking of timing.
Half hour to 45.
Right. Shall we try and finish that before we stop for lunch, or you want another break? I think I'd prefer to get on if we can.
Me too. If Mr. Akiki does not object, I prefer we go on. What time is the break? Is it 20 minutes from now?
Oh,
Lunch break.
We'll turn the break with your cross-examination. We'll see how we go.
Okay.
I'm not going to set a timing for the break, but rather that we finish the cross-examination. But if we have to break, we'll break. Let's carry on for the moment.
Okay. So just to close the issue where we were discussing, and your position confirming, you agree or disagree, it's very simple, Mr. Akiki, is that Reem to date have not substantiated their claims and therefore they're not entitled to anything. That's your position.
No, this is, I need to correct it slightly. They did not substantiate, yes, I do agree, because also Atkins, they were not able to assess. However, I did not say they are not entitled. I still insist that they are entitled for the delay claim related to the fire incident. I'm not saying they are not entitled. However, the discussion between me and Mr. Al-Mahdi, it was totally different. Still, the discussion is something, and if they are entitled or not.
I have not touched upon the 850 or 750 issue. I was just discussing the 4.5. So let's stick to what we were discussing. If I have the time, I will ask you questions about it. I re-examined Mr. Al-Mahdi on this, by the way,
No
as I'm sure my colleagues informed you.
No, not really.
Perhaps you saw it.
I was traveling. I have no communication whatsoever regarding this case with anyone.
Okay.
But then the friend will remember that we can't communicate with the witness. There was
Exactly. Yes.
I stand corrected.
Sorry, I did not get it.
Anyway, carry on with your question.
Okay. And just to close the issue, we agree that Atkins issued a determination and they found 0. And they said that there is not sufficient substantiation, but they issued a determination. Okay, great. Now, let's move on to another interesting clause in this contract, 4.10. Let's see. I think it's E394 ECHO. E394.
Isn't it 461?
No, sorry. Yeah. Yes, it's again, Mr. Akik is with the statement. It is mentioned there.
It's on page E461.
No, it's a page E394. E3, Your Honor,
Yes.
I'm looking. I want to discuss paragraph 84 of Mr. Akik's witness statement.
Okay.
You say there, you say this paragraph. This is you you comment about the inclusion of clause 4.10 in the subcontract. Just to give context, 4.10 is the famous indemnity clause. Do you understand what I'm talking about, Mr. Akiki?
I do understand.
Thank you. You do. So, and you say in this paragraph that, and to remind everyone, the language of 4.10 is in the preceding paragraph of Mr. Akiki's witness statement, paragraph 83. We can see in italics the language. So, in paragraph 84, you say that the addition of the clause was at the defendant's initiation. You see this? At Reem's initiation, you see this? You said that's what you say in your witness statement.
Yes.
The contract value was 47 million.
Yes.
There were extensive negotiations between the claimant and the defendant to award the subcontract. So there were negotiations, long, difficult negotiations. There was some hesitation from the claimant. However, to alleviate the claimant's hesitation, the defendant included the indemnity clause in the subcontract, as I have quoted above. You see this?
Yes, I see this clearly.
And then you go on in paragraph 87 and you say, frankly, the indemnity clause, it's paragraph, that's how you start paragraph 87, was very attractive to the claimant, and had it not been for the indemnity, we would not have awarded the subcontract to the defendant. That's obviously not true, isn't it? What I have just quoted is not true, is it?
Sorry, I did not understand the sentence. Can you please repeat?
What the two quotes from your witness statements,
Yes.
the passages from the witness statements that
Yes.
I just quoted,
Yes.
what you state there is not, is it?
It is true. Exactly, it is
It
true.
is true.
That's why I put it there.
You insist that it is true.
Yes, I do.
Okay.
If I may, I will explain why. Why I clearly remember this. Why I clearly remember.
Let me ask the questions, and then you can, as we said before, let me finish with these questions, and then you can go back. Let's look at the work order.
Yes.
The work order, which was for the same price,
Yes.
and which was executed in April 2016. Does the work order contain a similar provision?
No.
I can walk you through. It does not.
No. I mean, it's clear in my mind, and I will explain to you all this, the chain of thought. I will assist you at the end.
Okay. So, how on earth can you argue in paragraph 84 that there was some hesitation from the claimant
Yes.
to award to Reem a contract for the exact same scope, for the exact contract price, for which you were already 15 million late in payments?
Yes.
Roughly. And and we are now in April, May, June 2018, a year after
Yes.
you executed the works order, and you say that you were now in hesitation to award the contract.
Yes.
That's what you said. That's your language. State before.
Exactly. I'm not denying it. Just I need to explain the whole process.
Okay. Explain it now before I go to the next.
Thank you. As I said earlier, in the previous project, which is not relevant to a certain extent to this project, my contract is with the main contractor. and as you know, in the business standard, in all contracts, I seek indemnification from the main contractor for any kind of failure that might happen with the subcontractors. Okay, so that's established in the other contract. Now, due to the failure that happened in the other project by Reem, which I had to go after the main contractor to claim, which I have no problem because I have a contract with them. And I believe that Reem were delaying signing the subcontract agreement before, from the beginning to the project, after the letter of intent till the fire incident. That delay is mainly to deal with, in case there will be some similar failures by Reem, the contract of China State, which is an international contracting company, is very solid. And that's why they were trying to delay things and not to sign. This was the only subcontractor who did not sign with China State, the only contractor. So after the letter of intent, I had to sign the work order to keep things going. I was not happy to sign the work order. However, I was still believing that the work order will allow me to pay them some amounts until they will finalize the subcontract with the main contractor, which my indemnification from them, it will be through the main contractor. This is the natural way how it is. Now, after the fire incident, there is no novation agreement that can take place from the main contractor to me. So I was left face to face with Reem. So it means face to face. It means I have to enter now a serious contract with them. And based on all the previous experience with Reem that started from the other project, continued after the letter of intent that they refused to sign this subcontract agreement with the main contractor, saying the terms are not fair to us. After the fire incident, they tried to insert this clause, which I was not comfortable with, because I told them clearly the main contractor is happy to.
Which clause do you mean? 4.5?
4.5. Because I told them the main contractor is admitting and accepting, and this is the letter saying that he's responsible to pay you any extension of time or damages caused by the fire incident. They said, no, we don't care about this letter. We want to sign a clause with you. So after all these, then this is where the negotiation heavily, it took place to mitigate my concerns about dealing directly with Reem. Was this clause, the 4.10 that you refer to, and this was the heavy negotiation. And once they confirm that they are going to give us the indemnification, then I felt that this is somehow it will make the contract more balanced. And this is the explanation about why it was not in the letter of intent, why it was not in the work order, because the purpose of the letter of intent and the work order was to reach to a subcontract properly done with the main contractor, which did not take place due to the fire and due to the delays. So that's my explanation why the negotiation of this clause took place during the subcontract agreement and not during the letter of intent and not during the work order.
Right. So what you're saying is that because they wanted 4.5, you needed 4.10 for your security, right?
That's not what I said exactly. I said it was required due to the history of dealing with Reem. I felt that I will be not safe if I don't put this indemnification.
So you needed this indemnification to feel safe?
Yes.
Yes, because you said that this addition was at Reem's initiative.
Yes.
Not yours. And you insist that it was Reem's initiative.
Yeah, no, they offer. It was not in the subcontract. They offer this against also the comfort that we are giving 4.5.
Okay. So they offered it. They offered it themselves. It's not that we needed it to give them 4.5.
It was during the negotiation, and it was.
Okay, let's look at F820. F2820. Excuse me. It's F2820.
No, it's
2820.
2820. 2823.
Yes, it's okay.
You have 2820. Yes. Okay, it's 2823. Can we go to the top?
Okay.
Let's start at the beginning. Now, you see this document on screen?
Yeah, I can see that. Okay.
It's called subcontract agreement. And do
Yes.
you see the logo on the right-hand side?
Yes, I can see.
And do you see the date?
The date, let me read the date, 20 September 2017. Yes.
Okay. And above this, ref, JVC, brackets, TI, SCI, these are 5
Yes.
references, right? Okay, let's go down. Let's go please to clause 13. Can you read? We are at page 72823. F2823. Sorry, F2823. Can you please read for me clause 13?
Clause 13.
Yes.
Yes, the subcontractor shall indemnify the employer from and against all losses. Yeah, this is the clause. Yeah. Arising.
So does this
Correct.
look familiar? Does this look familiar?
Yes, familiar.
It is word to word 4.10 of the subcontract.
Yes.
Do you know what this document is, Mr. Akiki? Do you recognize this document?
This is part of the subcontract negotiations that we were doing with Reem after the fire incident to enter, instead of the main contractor, to enter in a subcontract agreement with them. This is exactly
That's not entirely accurate. What you just said is not entirely accurate.
Why?
Because it is the first draft of the subcontract which you sent.
Yes, but
let me finish the question.
yes, please.
I put to you that this is the very first draft of the subcontract that you sent to Reem for the to sign. And this very first draft included the indemnity clause.
Okay. May I?
So I put to you that it is at Five's initiative that the indemnity clause was included in the first place.
If you are suggesting that this first draft is the first negotiation with Reem, that's not accurate, because we have negotiated before this draft. Maybe this is the first draft that we are able to identify in emails, but this doesn't mean this is the beginning of the negotiation. As simple as that.
So what you're saying is there were previous negotiations. Were there emails exchanged on this?
I don't recall. I need to check my emails. I need to check.
Okay. We have to. So you're saying that we have to take your word, your credible testimony that in a previous instance, Reem told you that when you prepare, you prepare the first draft of the contract, and when you prepare it, make sure to add a clause, an indemnity clause that satisfies you, and send it to me to negotiate. This is what we testify.
We have
yes or no?
No, I'm not suggesting my word against anything. What I'm saying, I'm witnessing to what I remember and what I believe, and what I still remember clear, that this thing has been discussed and proposed before the draft, as simple as that.
And I will again, because at some point we need to agree that today is Wednesday and the time is in the UAE 2:12 and outside there is sun. Your wording in your witness statement is The addition of this clause was at the defendant's initiation.
Yes.
So your testimony is that Reem asked for 4.10. Yes,
Yes.
I show you the very first document
Yes.
that started a real negotiations on contract, not talking clauses, paper to sign. We agree that this document was sent from file. Yes.
Yes.
We agree that this first document had a clause which was identical, copy-paste,
Yes.
what was eventually 4.10, and you insist that it was Reem that asked you to include it in your own first draft. Yes?
Yeah, it's very
Yes.
simple. Sir, you are a very professional lawyer.
Yes.
A clause of indemnification, it can be discussed by two people very simply saying, I will indemnify you, because if I have a concern and I'm saying why I have been led to sign the contract directly with you without the novation, without the subcontract that you have signed with China State, then they offer me, we will indemnify you. As simple as that. Why this is so big, and it seems like we are reinventing the wheel. It's a simple clause of indemnification, but the idea is, yes, they have proposed this to me.
Because it's the fourth time that you were caught lying, Mr. Akiki. That's why it was important. Fourth time.
Okay.
Yes,
That's
number 4.
These are your words.
Let's,
These are your words. These are your words, which I
fine.
do not agree with you at all. I mean, you know more. You know more if the sun is shining in Dubai or no. It seems. I don't know.
Let's go to page E Echo 380 of the bundle.
Can I just ask, before you go there, can I just ask something, Mr. Akiki? We've just been looking at the first draft of the contract.
Yes.
Yeah? And you've had pointed out to you clause 13, which is the same as clause 410, as was eventually agreed. Yeah.
Yeah.
Was there an equivalent in this first draft of 4.5?
Can we look at it, please? Because I don't.
You don't have a copy. Could it be put on screen, please?
One moment.
It's F2822 2821. Could you scroll through so Mr. Akiki can have a look at it?
Thank you.
I think clause 8 is relevant here. Relevant to your question, Your Honor.
Well, I just want to ask.
Mr.
I just want to ask Mr. Akiki first, and then.
Can we please continue to see the down if there is anything upon completion issues? Yes, Your Honor. It's not included. The 4.5 was not included in this draft.
The reason I ask, Mr. Akiki, perhaps is obvious, but you, in one of your earlier answers, you linked, to some extent, the insistence on 4.10 with the fact that Reem were insisting on 4.5. Now, I know it's more complicated than that, but they were linked to some extent. And that's why I was wondering whether there was any equivalent of 4.5 in this first draft. Now, I don't know if you have any comment to make on that.
My comment, Your Honor, it's the situation that I was not comfortable at all to sign a direct subcontract agreement with Reem. And from the beginning, they knew that, because normally they are the only subcontractor that they did not go through the main contract. For me, the first and the biggest safety is signed with the main contractor, not with the subcontractor. So that's why the discussion, it started at that time, even though there is no clause inserted there. But immediately after that, the discussion continued that they said you need to indemnify us for the fire incident from the main contractor if they will not pay. And that's why there is a letter which took place. I did what they have asked with the form of a letter from the main contractor. And we had several meetings with the main contractor and Reem together to come up with a certain form of safety or security for Reem for the extension of time during the fire. So this security came in a form of a letter from the main contractor, which they did not accept. They said, we want to put it as a clause in the contract. So it came at a later stage, but my concern was from the beginning signing a direct subcontract agreement without novation from the main contractor. And that's why the discussion took place. And they said, do not worry, we will indemnify you if we will delay. We will not delay. So they were saying, we want to sign with you directly, not through the main contractor. But I see your point that the link that I mentioned, it was not visible in this draft. I do agree on this.
Thank you very much. Sorry, Mr. Carvelis, I intervened in your cross-examination, so excuse me. You're muted.
Apologies. You just opened another front, Your Honor, which though I don't think I will. Yes, I will move on because I think we don't have the time. I think it's clear. Can you look, Mr. Akiki, at page Echo E380 of the bundle? Now it's the time.
E what?
E380.
Right.
It is now the time to discuss the 750, 850 agreement or no lack of agreement you had with Mr. Salim.
Yes.
Okay. You say in paragraph 31 of your witness statement, this is your second witness statement we see on screen. I had extensive negotiations with Salim Ahmadi during a phone call in or around the end of August. It was understood that the claimant would make an offer of 750 for the damage claim and that the defendant would no longer make spoliation claim as a result. Do you stand by this statement today, Mr. Akiki?
Yes, I do.
You do. Let me take you to page 71946, the bundle.
1946 of what letter?
F1946. F19 F. Fiesta. I'm not sure, Your Honor, by the way, this numbering, they use letters and numbers. It's very helpful.
It's fine, but I often don't hear the initial letter. That's the only thing. Thank you.
It might make more sense if it was just, which is a continuous numbering, actually. It's on screen. This is an email now from Mr. Vimal Mohan to Salim Ahmadi, sent on 19th of August. Do you see this?
Yes.
And here I see Mr. Mohan says to Mr. Ahmadi, we have agreed to meet at 4:30 today to conclude the fire damages. And there is also a bracket materials claim. You see this?
Yes, I do.
And you were CC'd on that email, right?
Sorry? Yeah, I was CC'd, correct.
So I guess we can agree that when when Vimal said to Salim, we will meet to conclude to discuss the fire damages material claims, this means only the direct cost, the materials, not prolongation.
Yeah, this is what is written here.
Okay, great. I'm glad that we could agree. No, so after this meeting,
Yes.
and this meeting happened on the 19th of May. So you said that there were further negotiations, right?
Yes.
And presumably during that period, you had this famous phone call with Salim.
Yeah.
And this phone call, it is when Salim agreed to go to its management and settle everything for 750.
Yes.
Correct?
Yeah, that's correct.
This is what happened. Now, let me ask you if it makes sense for you. Yeah. We discussed earlier that in May 2018, which is what? 3 months earlier, a year earlier, 15 months earlier, a year earlier, Mr. Al-Mahdi was pushing negotiations on behalf of Reem to ensure that 4.5 would be included. That in other words, Reem would be compensated for the loss and damage it suffered as a result of the fire incident. You told us actually that, and you said it not to us, you said it to Mr. Marzouki, that you agreed to this on a very exceptional basis, right? You remember this, correct?
The clause 4.5, you mean?
Yeah, the protection of Reem.
Yes.
We agree so far to that.
Yeah, we do.
Okay. You said that in June 2018.
Yes.
And you did this. We showed you the timeline. Only minutes after you had the confirmation from Salim that their prolongation claim is reduced to 3.5 million. I showed you earlier the email of Salim, and I showed you the timeline. A few minutes after, you texted Mr. Marzouki, once you had the 3.5, okay, let's sign, 4.5 will be in there. I make this exceptionally for you. Do we agree so far?
Yes, we do.
We agree. So we agree also. So we agree that at some point the prolongation claim had settled at 3.5, the number as a number. We agree also that the 1 million dirhams value of goods and materials has not been disputed. No one has disputed since it was first submitted in 2017 that the real value, the actual value of materials were 1.1 million, 1.1 million. Do we agree?
Yes.
Okay. If it adds anything, in all this time, in all the submissions that Five has made in this case, they have never disputed in any way whatsoever that the value of materials lost was 1.1 million give or take. So what we have now, and that's where I need your, if it makes sense to you. So you say it was that after all that, Salim agreed to, what is it? Out of 5 million, 4.5 million claim, to receive 15%, how much is 850? 750, 850 doesn't make any difference to the 4.5. You are better in math than me. It's 15%. It's 20%.
I'm not
He
sure.
agreed at that point.
Yeah.
He agreed at that time, orally, over the phone, to 15%, to get 15% in settlement of everything. This is your testimony.
Yes, this is my testimony.
And you find this reasonable?
I find it very reasonable, and if I may explain why. Yeah. The discussion was clear with Salim, and there are two figures. There is a big amount for extension of time, and there is a smaller amount for the material. And they were insisting at that time to take it in writing, which is, for me, it was very premature to agree on any delay damage or material damage, because that's not the spirit or the intention of the clause 4.5. 4.5, they have to go to China State and deal with their claim. And if China State will fail to comply with their obligations, then the plan B will be me. I'm not a plan A. But they were always, after signing the contract, looking at me that I am the plan A, and they don't care about the contractor. So when he came, Salim, and discussed that we need to close this one, then I told him, what is the amount? We discussed 850 or 750, but also he said, send the letter 750 and I will check with my management, which they did not agree on 750. They came back with 850. Then I asked him clearly, what about the extension of time claim? He said, that's something else. We will not go after that. I saw it's reasonable, because I believe from my discussion with Salim that claim was not substantiated, was fake. And this claim is the serious one. I felt genuinely that this is the money. If they will secure it, they will feel safe, because that's more important for them than the big amount. Otherwise, now the question is reversed. What kind of logic is, if you have two baskets in your hands, one basket value is 4 million and the other basket is 850, and you have to drop one of them, which one you drop? Definitely you will keep the 4 million and you will drop the small one, which they did not make. They insisted on the small one, and they said the big one we will drop it. This is what happened. That after that, and that's why my letter, when I wrote the letter to them, I clearly said the fire incident damage, work compensation for work and material. And if we can put it on the screen and read it, there is a reason why I differentiated between two things, and I put the value of 750, which later on came 850. So I am very clear in my mind what I discussed with Salim, and what I reflected in my letter after the discussion with Salim. It's not only based on an assumption or word against word. I put it in the letter.
We will look at the letters and what did you put there. But let me repeat. What you're saying is, I will use your own words. They had two baskets in their hand. They had a basket of 4.5 million.
Yes.
They had a basket of 850,000. And they decided to drop the 4.5 million basket.
Yes. And
to
secure.
Keep,
yes.
And keep, this is your testimony. That's what you said. Salim agreed to, sorry to repeating myself, but I need to understand that this is what you're saying. Salim agreed to drop the 4.5 million basket and keep the 850,000 basket. This is what you're saying.
Yes.
Yes, excellent. Let's look quickly these two letters that you have just mentioned,
Yes.
your famous correspondence. One F Fiesta 1965, Your Honor. You say here.
Yeah.
You can see it, right?
Number 2, if we read number 2, yes, fire claim for damaged works and material. So
Okay,
these
so
two different things.
Yes, exactly. Yes. And you say in trying to find the paragraph. Yes, it's the last. The last line. 5 has assessed the claim and agreed to an amount of 850,000, which has been reviewed and agreed by Reem. Correct?
Yes, that's correct.
And before that, 2 lines above, 3 lines above, second line, and let me take it from the beginning, concerning the above-mentioned subject and reference correspondence, and with reference, this is the famous clause 4.5 of subcontract, right?
Yeah. Yes.
Both parties have agreed that there is the word, any claims related to the fire incident,
Yes.
be part of China state's liability.
Yes.
And 5 has assessed the claim and agreed to an amount 850,000.
Yes.
So you say here that you told Reem 850,000 you agreed to, and they have, correct? This is what you're saying?
Yes.
You are saying, and you are, and you say, and I read paragraph 32 of your witness statement, 1, 2, 3, 4, 5 lines down. It's, Your Honor, the second witness statement of Mr. Akiki. It should be E3. I don't have the page number, Your Honor, excuse me, if you can assist.
It is E381.
E381.
Yeah.
Your words, Mr. Akiki, is this was accepted unequivocally. What does unequivocally mean, Mr. Akiki?
Sorry, can I see the document, please?
Yes, it's your own witness statement. I'm
Yes.
sure you saw it when you signed it.
Yes. Can I see it, please?
Yes, yes, of course. You see, it's 1, 2, 4, 5, 6 lines down. This
Yes.
was accepted. Did you see? Unequivocally. What does unequivocally mean?
It was clearly and like very like final agreement, but they accepted and it's a final acceptance. But then after that,
I asked you, excuse me, I asked you, what does the word unequivocally mean? The word, what does it mean unequivocally? Does it mean the word unequivocally?
yes,
Fourth word in this sentence. Does it mean without any doubt?
yes,
As a word,
yes,
by the defendant through its letter of 28 August 2019. You see this? You say it
Yes.
was accepted without doubt through its letter.
Yeah.
Let's see this letter now, where Reem accepted without doubt. Your words again, not mine.
Yeah.
The
pages is-
subcontractor. This is in page F1966, Your Honor.
Thank you.
Okay, let's see now the first paragraph of this letter. How does Mr. Al-Mahdi respond to you?
Yes.
Mr. Al-Mahdi is saying to you that the subcontractor hereby confirms its acceptance for the damaged material caused due to the fire at site for the value of 850,000. You say in your witness statement that without doubt, your own words, through this letter, again your own words, they agreed to settle everything, including prolongation costs at 850. We have this letter on screen. Do you insist that it is this letter that it is in this letter that they agreed to include material and prolongation and settle them at 850? Do you insist on that?
Yes, that was the way how they led me to believe that they accept. And here the question is for them why they did not mention in this letter that there is another claim that we will pursue. That's exactly what happened. So I was led to believe by Salim that this is the final settlement, which I reflected in my letter. He answered to this in a very hidden intention by referring only to the material without tackling the other part, which is the damage work. And then I understood this later that they did not accept on this and they are continuing with further claims.
So again, because at some point we need to agree what time of day it is. We have a meeting on 19th of August. The sole purpose of the meeting is material damage, damaged material and the value. We have at some point later on a phone call, a mysterious phone call between you and Salim, where he agrees to drop a basket of 4.5 and keep a basket of 850. You sent a letter where you sneak in the word any claim. I put to you my own opinion, hoping that they will not notice. Where you say that everything, any claim is 850, Salim responds immediately, saying, my friend, 850 for materials. That's what we have agreed. And your testimony today is that no, they misled me. I thought 4.5, I thought they included everything. Is this what you're saying? It's very simple.
That's exactly what I'm saying. And they are the party who they sneak this letter without excluding part of my letter. So it's not the other way around. It's not me who I sneak into the letter. This was a clear discussion. It's a clear understanding. And they play around the wording by putting only material, removing the other part. This is the reality.
Okay. And can you tell me again what is it that you do for a living?
Sorry, what is my?
What is it that you do for a living? You are the CEO of the real estate division of 5, correct?
Yes, that's correct.
Thank you. Your Honor, I have the last part of my cross. It's not long, but it has to do with Five's claim against Reem, the indemnity claim. And I suspect it may take a little bit of time with Mr. Akiki on this. I don't know if you would prefer to have the break now and continue afterwards.
Let us stop for lunch at this stage. Can we keep the lunch period to 1 hour?
I have no objection to this, Your Honor.
and we will resume at 12:45 UK time at 15:45 your time.
My lord, may I make just one comment, please, if I may? I don't mean any discourtesy at all, and I mean that when I say that. But we've been with Mr. Kiki for a very long time, longer than anticipated,
Yes.
even on a worst case basis in terms of the timetable. Certainly, we on our side, we've tried to keep to it, and I think this is becoming a bit, we're going over the allotted time. So I would say that there needs to be, I would encourage that the cross-examination be really far more fine-tuned if possible. I don't mean that discourteously, as I say, but I just say it in terms of timing, because we've got experts to deal with as well.
I've been keeping an eye on the timetable. We have exceeded, we've gone beyond the table, but it seems to me there was room on day 5 to catch up and finish the experts. But perhaps I can encourage Mr. Carvelis to conclude fairly briefly after the lunch break. And will we get on to Mr. Lowe today?
I will. Sorry, I don't mean to cut across it.
No, please.
I was just going to say, in terms of re-examination, I do have quite a bit, maybe half an hour or so.
Okay.
But
well, we'll see where we get to.
We'll see where we get to. Yeah.
Okay.
If it is up to me, Your Honor, and my dear friend, it would finish immediately. Most of the questions can be a yes or no.
Yes, but the trouble is you ask a very, very long question, which includes many contentious matters. Anyway.
But still, the answer can be yes or no. It's the comment that takes time usually.
I think you're being unfair to the witness. Let us resume at 12:45 UK time, 15:45, and don't speak to anyone about your evidence in the meantime, please.
Understood. Thank you.
Right. Thank you very much.
Thank you again, my lord. Thank you.
Thank you.
Good afternoon.
Good afternoon, Your Honor.
Are we ready to resume? Good afternoon, Mr. Neki.
I'm not sure where he's here.
To resume when you are.
Yes, he's here. I'm ready, Your Honor.
Yeah.
Okay. Mr. Agigi, I think it's the last part of the cross-examination. Following that, my colleague surely will have some follow-up questions, re-examination questions, so we shouldn't take much more of your time. Let me again recap what we have established these last 2 days, which are relevant to what we're going to discuss. You testified that you are the CEO of Fred Real Estate Development, which is the claimant in this case, right?
Yes.
And
That's
you
correct.
are also the Chief Executive Officer of the Real Estate Developments division of Fred Holdings, of 5 holdings.
Yes, that's
Am I
correct.
correct?
That's correct.
And I think we established last Monday, that Fred Real Estate Development, the claimant in this case, Unlimited One, the hotel and the hotel manager, 5 hotel management, I think it is called, are all companies which belong to 5 holdings.
The same group, yes, that's correct.
And the parent entity of the group is 5 holdings. And I think you said that you are not a shareholder in any of the companies of 5 group.
That's correct.
You don't have in any of the companies in
That's
5
correct.
group, correct?
That's correct.
And I understand that the main shareholder is Mr. Kabil Mulchandri. I'm not sure how it is pronounced, his name.
Yes, that's correct.
Okay. And you also told us that the claimant in this case, 5 Real Estate Development, is a special purpose vehicle, an SPV without any other activities.
Yes, that's correct.
We will, does the owner, Unlimited One, does the owner have any other activities?
Unlimited One Limited, no. They are only the owner of this property. They do not have other business activities. Yeah.
So they are an SPV, so to say.
I'm really not sure if I can call it SPV, but they are the owners of the property. The SPV is for services, maybe. I'm not. This is a legal background I cannot comment on, but yeah, Unlimited One Limited is the owner of this property, and they do not have other business activities. That's correct.
Or any other assets other than, the land and the building.
Yes, they do not have other than this project.
Okay, thank you. Now, Unlimited One and the claimant, 5 Real Estate Development, entered into a property development contract. I think which is common ground, and we will agree on this. Correct? Your Honor, we will, if we can have it on screen. If you can give me
E399.
a second.
E399.
Yes, it's E39. It starts at E398. Yeah, it's E399. And we can see it on screen.
Yeah.
If you can, look at this quickly, at this contract, I'm looking at it here. We see clause 6A. Do you see it, Mr. Akiki?
Yes, I can see it.
So it's clause 6, paragraph A, which says that here that the second party, I understand that this is Fred Real Estate Development, the claimant, undertakes, agrees to construct new buildings on the plot. The dates are not relevant, and agrees to bear all necessary costs towards this. No, I'm sure you will agree with me that the language is not very, very clear here. What I mean by that, who was supposed to pay for the actual construction cost, the 680 million dirhams? The way I read 6A, it seems to me that 5 Real Estate Development would have to pay this 680 million. Would you agree with me that it is not a very clear?
This is the responsibility of 5 Real Estate Development through the sales and the SPAs and the collection in the escrow account to pay this amount. That's correct.
So I ask this because in one of the submissions, I think it was the defense to counterclaim. When we raised first the point that, if I understood correctly what you said, 5 Real Estate would have to pay 680 million and receive a fee of 11 million. So it would have, that would not make much sense. Would we agree on this?
I mean, it doesn't make sense. This is your statement, but I do not agree. It makes a lot of sense. But again, I would like to clarify what is the obligation of 5 real estate development. As you know, in Dubai, the land department, they do not allow the owner of the land to develop it directly. So, for example, Unlimited One Limited, which is the owner of the land, and to start development, you have to go through a registered real estate development company, which is 5 Real Estate Development. So the obligation of 5 Real Estate Development, again, I will say it again, is to procure these funds through the escrow account from the SPAs, from the sales and purchase agreements signed with the individuals, and then to fund and to pay the construction through this procedure. So, but this doesn't mean that 5 Real Estate Development is the owner of the land. The owner is Unlimited One Limited, but the company with the obligation of the company is to procure this amount from the escrow account and to pay it to different services, which are contractors and others.
I do not disagree that the real estate regulator, RERA,
Yes.
RERA,
Yes.
requires where the owner and the developer are separate persons to
Yes.
a property development contract which has to be registered. I totally agree with you on this.
Yes.
What I'm trying to understand is who paid for the construction of the hotel. Is it 5 Real Estate that had the money, the 680 million that was required, or it was Unlimited One who gave to 5 Real Estate the money to pay the contractors and whatever else required?
Yes. The source of the money came from 2 different sources. One is the investment of Unlimited One Limited, which is the equity. Let's call it the equity. And the other source of the money is raising funds through the banks against the land and the SPAs, the sales and purchase agreements, where the proceeds they come into the escrow account, and then these payments will be paid by 5 Real Estate Development.
I understand this, but I guess because it's a hotel and not a residential building where the majority of the units are sold to third parties, and it is meant to operate as a hotel, presumably equity, bank loans, financing, third-party financing, bank loans, were the primary source of financing for the project. Am I correct?
Yes, that's correct.
And this came from the owner, Unlimited One, not from 5 Real Estate Development.
They were jointly responsible for the loan, and in the loan agreement with the bank, they are equally and jointly responsible because, as you know, in the regulation of Dubai, the main responsible for the development should be 5 Real Estate Developments. So they do not communicate with the Unlimited One Limited as a land department. They hold responsible 5 Real Estate Development, and that's why the banks, they insist on having signed jointly by the 2 parties, which is the owner of the land, Unlimited One Limited, and the developer, which is 5 Real Estate Development.
But I guess, especially the banks, they require the signature of owner one, for Unlimited One, because Fred Real Estate Development does not have any revenues.
Yes.
Right? And they don't have any revenue today, right?
Yeah, the bank, they look at it, you are right. They look at it from this angle. Land department look at it from a different angle. Land department look at it that 5 Real Estate Development is the main responsible. And by the way, this contract development agreement that we are seeing on the screen, not now, 5 minutes ago. This is a specimen or a draft, which is a standard given by land department to the real estate development to sign it without changing any clause. So if there are few things not very clear, which I do agree with you, there are some points which they look weird, but when I look from the perspective of land department, I understand why they are trying to hold the developer more responsible than the owner of the land.
You preempted my next question. Thank you for this, because I was going to ask you if this is indeed the standard form. This contract is in the standard form issued by RERA, which is indeed the case.
Yes.
Okay, I'm glad we established this, and I suspect also, or I'm told, to be honest, that the Arabic text may make a little bit better sense than the English translation in this document. Anyway, it's not important, and it's not. I wanted to understand the background.
Yes.
But I have to ask you the question, though.
Please.
Considering that Fred Real Estate Development does not have assets, does not own the hotel, obviously, or the land, and does not have revenues. If, God forbid, His Honor decides that you have to pay Reem 1 dirham, who is going to pay? Who is going to pay this 1 dirham?
Is this a question that needs to be answered, my lord? It's about the reason why I say I interject. Can I just make my objection? I just want to make. Let me just make my objection. It's because we're here to determine liability and any quantum that follows thereafter. Whether who's going to pay, when the payment will be, these are matters for separate.
I agree, Mr. Kushtel, but it seemed to me if it was simply illustrative of the question, then it's permissible to. I assume the questioning is going to a particular point, and I have in mind a point. I may be wrong. If it is going to that point, then the question, as precisely asked, may not just go to the question of enforcement, but may go to the question of loss.
Yes, certainly. No, I don't. I have no issues on the questions on loss. I accept that. But I just wanted to clarify where we're going, because if it's loss, so be it. But if it's enforcement, then I don't think that's appropriate.
I think, am I right, Mr.
There were follow-up questions. Yes, Your Honor, you preempted me. Yes, that's where I was going to. It's a matter of it goes to the loss, indeed.
Very well. I think carry on that basis.
So, Mr. Akiki.
Yes, can you please ask the question one more time, because it's far away.
Considering what we established so far, that real estate development does not have any assets or revenues.
Yes.
If there is a future obligation, for example, the one that comes to mind, because I cannot, you said that you don't have that. Fred does not have any other activities. The one activity, quote unquote, activity that we know is this trial. And this trial may result to a debt or a credit. If it is a debt, how is it going to finance the service of this debt?
The answer is very simple. 5 real estate development have never declined or defaulted in any obligation or payment, and I think in this in this case that we are ongoing, also 5 real estate development has been requested to secure some cost and pay, and that's something. It's the obligation of 5 real estate development, and I assure you that this will be paid. Whatever is the obligation of 5 real estate development will be paid.
So is it fair for me to assume, if I assume that, again, it will be equity financing, equity if necessary? Equity.
Sorry, the question is not equity, I understand, but what is the question, if you don't mind?
So is it will I be right to assume, based on what you just told us, that if needs be, there will, if for any other obligations of 5, it will be again equity from, and I mean from its parent entity.
I cannot answer the future like this.
Okay, it's,
Let's see.
I can understand. I can understand. I don't insist on this. It's not really important. Let me go to the follow-up question.
Yeah, please.
Right. So, at paragraph 77 of your second witness statement, which is E38, and again, I'm at the mercy of his honor for the
E393.
You state, Mr. Akiki.
Yeah.
The claimant, Fred 5 Real Estate Development, was in breach of its property development contract with Unlimited One.
Yes.
So, due to Reem's actions in delaying the completion of its works, and as a result, delayed completion of the project. You see this, right?
Yes, I can see this.
And I suspect that you stand by
Yes.
the accuracy of that statement. You insist on that. Right. Let's have a look now at page E179, which is the E1719, which is the letter from Unlimited One to,
yes.
you see the notice, the famous notice of demand.
Yes.
And you will agree with me that this letter is signed. We go at the bottom of the page by Mr. Kabil Mulsandani. I'm not
Yes.
sure if I pronounced it properly, which we agreed that he is the owner of all these companies, the majority shareholder of all these companies through 5 holdings, through the group entity. Correct?
I mean, you put it that way, but again, we said clearly at the beginning that the owners of 5 Real Estate Development are 2 companies, which are not Kabir Mulsandani. But if you want to put it as part of the group, that makes sense as well.
Okay, thank you. Now, this is a claim because Reem is in delay, correct? This is a delay related.
Yes, that's correct.
Okay. It is not a claim because of defects, for example, or other damages suffered. It's a claim related for the delays caused by Reem.
Which claim? Can you please clarify? Now I'm.
You say that, okay, with this letter, Unlimited One notifies 5 Real Estate Development that it suffered a loss of 11.9 million and change.
Yes.
And I'm asking you to confirm that this is all due to the delayed completion of the project by Reem. Am I right?
Yes, that's correct.
Caused by Reem. It is not a claim for defects.
No.
We discussed earlier bad acoustics in 5 Palm, out of specs work. It's all delayed.
That's correct.
Right. Now, as part of these proceedings, 5 engaged Mr. Stephen Millington of Forensic Risk Alliance, right, to, and I quote, assess delayed damages pursuant to Clause 8 of the subcontract agreement. This has nothing to do with this. correct? Estimated gross operating profits that would have been generated during the delay period, correct? And additional costs incurred by 5 real estate development, the claimant, during the delayed handover period.
Yes.
Correct? The
That's
three, in other words, to assess the 3 heads of claim, these are the 3 main 3 heads of claim of 5. You have additional ones, but this is it. Right. I have to say, first of all, how was Mr. Millington engaged? Was it engaged by, we can ask Mr. Millington later, but if you have the answer, it might save some time. Was he engaged by 5 or by counsel on behalf of 5?
I think by 5 directly, if I'm not mistaken, but I prefer that you will ask further to make sure. But as far as I know, it's he has been engaged by 5.
Okay, it's not that important for this discussion. Now, it strikes me as bizarre, if I'm honest, that you instructed an expert to investigate. On one hand, the same expert will have to investigate a claim under the subcontract agreement between 5 real estate development and Reem, and at the same time, a claim against 5 real estate development by the owner. It strikes me a little odd. It strikes me that the interests here are not entirely aligned between these 2 claims. Can you understand what I'm trying to say? Do you see what I'm trying to say? Do you see this unusual situation? Mr. Millington is asked to assess the claim from 5 real estate's perspective, and at the same time, from the owner's perspective. Is it perhaps because these 2 perspectives are one and the same?
You're asking me the question? This is addressed to me, the question?
Yes.
Yes. So again, we need to respect the corporate structure of the group. The corporate structure may be one of the reasons why we are successful, because we treat each and every company is independently, and every company, every entity of the group has obligations and responsibilities. So yes, the claim, I mean, to explain the background of what you are saying and to clarify. So there is a fact that the hotel has opened later than what has been agreed in the in the development agreement between Unlimited, One Limited, and 5. There is a fact, and there is definitely if you don't open on time, there is a loss. Now you can call it GOP or else. This is something again for the expert to debate and for the court to decide. But definitely there is a loss in the absence of the project, the hotel opening on time. Not only limited to the hotel operation, but also there were many default by or cancellation by purchasers due to the delay. They did not want to continue with their SPAs, and they just move away from the project. So all these against this, Unlimited, One Limited has put 5 real estate on notice, knowing that the main delay and the major delay and the delay that we are discussing is caused by Reem. So consequently, 5 wanted to assess, I mean 5, when I say 5, or the group wanted to assess what is the amount of this damage that has been caused to the owner and consequently to the operators and so on, due to the delay in opening the hotel. So it is like that. Now, I don't see misalignment of interest here at all. I see 2 entities which they are in a corporate structure. Every entity is doing its own obligations and responsibilities.
So you're saying they acted totally independent with each other. So the Unlimited One and 5 real estate development acted totally independent.
Yes.
This is what you say.
Yes,
So,
that's correct.
So presumably, if they ask, if the two entities acted independently, and if this is what we would call legally an arm's length transaction and an arm's length claim, then presumably, again, 5 Real Estate Development, as the debtor in this claim, may or may not agree with its creditor, Unlimited One, about this claim. They may have some defense of their own.
Yeah, I mean, that's why they should refer to an expert. This is, I mean,
yes.
There is no party can decide on behalf of the other. They both rely on a professional expert to assess and to decide.
Yes, but the thing is that the professional expert is a forensics accountant, and this is not an issue of quantum. I was talking about liability, whether 5 Real Estate Development is liable and the extent to which liable to the owner. Let me ask you differently, and perhaps this will help you. Now, you must have been in an awkward position, because on one hand, as a CEO of 5 Real Estate Division, you had a claim for us, the owner of the hotel, ultimate beneficiary of the hotel, and at the same time, you were the CEO of the entity which had to pay the beneficiary. You must have been in an awkward position. Now, when you received this letter, as CEO, put yourself now, wear the hat of 5 Real Estate Development CEO. Did you ask your lawyers to have a look at it? You said you act as independent entities. Did you ask your lawyers to have a look at it?
Yes.
To have a look at this claim?
Of course, I discussed this with my lawyers, of course.
I think you told us that you don't have lawyers as 5 Real Estate Development.
That's not what I said. I said that there is a legal department which they do services for this and that entity. This is what I said. I remember it clearly, but maybe you forgot.
I agree that this is what you said, and this is 5 Group's legal department, correct? This is the legal department of 5 Group. It services all of the companies of the group, correct?
Yeah. Yes, that's correct.
Presumably, it is the same lawyers then that they drafted this demand notice for owners, for Unlimited One.
This is what you are saying. I don't believe is the same lawyer is drafting a letter, but finally, this is one independent entity is putting on notice the other entity. The core of the discussion here that there is a delay or no? Yes, there is a delay. How much is the quantum of the loss? That's the point. Who signed what? I mean, if you want, I can ask and I can come back. Who drafted what?
I'm not necessarily. I don't necessarily. I'm not saying that necessarily. The same person drafted this notice under the letterhead Unlimited One, and the same person, and you gave it to the same person to look at it, wearing now the hat of 5 Real Estate Development. All I say that they are both colleagues. They are both. You didn't give this notice to Alaidarus, for example, to tell you if this is a serious notice or not, if it is a claim that you are indeed liable. You did not, did you? Did you give it to Alaidarus, for example?
Can you let him answer?
So, Your Honor, I did not.
Go ahead, Mr. Akiki. I was trying to stop the question so you could answer.
Oh, thank you. Thank you, Your Honor. I mean, the way how I see it, Mr. Karvelis, this letter has been signed by a representative of Unlimited One Limited, which is Kabir Mulchandani. And it has reached to me, which I'm the CEO of 5 Real Estate Development. It doesn't matter who drafted what. It might be a secretary, it might be a legal advisor, it might be the neighbor. I mean, there are two letters from one entity to the other entity, and based on facts and based on losses, are we discussing now who has taken the pen and which color he has drafted it? I mean, I don't see relevance, and I don't know, to be honest with you. If you want, I can ask, but as of now, I don't know who drafted this letter and who checked it from the other side. But I know that these two entities, with their legal representative, they have put a notice to the other entity.
I don't. It's not. There's no need to ask anything. I had you what I needed from you. Maybe what you said. It's like different colors of the same thing. Doesn't really matter. It's the same. It's the same group, the same pocket. Right now, be that as it may. You had Mr. Millington assess it.
Sorry?
You had Mr. Millington, be that as it may. Anyway, let's move on this discussion.
Okay.
You had Mr. Millington assess it. Mr. Millington did his assessment, and we will discuss it later this week. And Mr. Millington, in his assessment, he came back and he said, no, it's not 11.9 million, it's 9 million. I think there was something,
yes,
the calculation should be made different, it's 9 million.
Yeah.
We will not discuss whether Mr. Millington is right or wrong, and whether he did the proper calculation. This is not for this discussion, this is with Mr. Millington. My question is simple. When you received Mr. Millington's assessment, which is the only assessment, you said you did not ask lawyers to look at it.
Yeah.
It's the only assessment.
Anyway, yeah, okay, let's move on with the discussion. But I don't recall that I said I did not ask lawyers to assess it. But
that's exactly when His Honor stopped me. When I asked you if you gave this notice that we discussed, we had on screen, if you gave it to a lawyer acting not for Unlimited One, acting for 5 real estate development, to tell you as CEO of 5 real estate development, if this is a valid claim or not.
Yeah, I mean, I discuss it, yes, with lawyers, but also I assess it myself. If it's a valid letter or not, I assess it myself first. But of course, I discuss it with lawyers as well.
Which lawyers?
The group, part of the group, the lawyers. Yeah.
So conceivably, the same lawyer who drafted the submissions in this arbitration before engaging Alaidaros. Perhaps, or part of the same group.
Yeah, we are repeating the same discussion, Mr. Karvelis.
Yeah,
I think I have answered this. If Lord Angus would like to listen again to the same discussion, I'm happy to do it. But if there is no way out of this circle,
No, thank you. No, thank you.
Thank you.
Now, you have Mr. Millington's assessment, who says that it's not 11.9 million, it's
Yes.
9 million. Did you notify Unlimited One? Did you say to Unlimited One, you have a claim which is, you can't claim so much money from me?
No, they are aware of this. There are discussions. I did not notify. I'll tell you why. Because we are already in the case now, and this report or this assessment from the expert is in front of the court, and the court will decide. So there is no need anymore to just keep notifying each others about this. It's very clear for us, and it's in front of the court. So we will wait for the court decision, and then we will see how things will go.
So what you're saying is that it was very important that they notify you formally that they have a claim against you for 12 million dirhams?
Yes.
But it is not important to notify them that your expert, not lawyer, who might have more to say, by the way, a lawyer might find many more defenses against Unlimited One's claim against 5 real estate development. An independent lawyer, I mean, who would actually look into it. But once your expert came back and said it's 3 million less,
Yes.
give or take, it was not important to tell this to Unlimited One. It was not important to tell to Mr. Kabil, you have million claims.
Sorry, that's not what I said. I said there is no notification in writing because they are aware. They know clearly what is the opinion of the expert. And now we stop communicating about this because we are waiting what the court will say. I did not say it's not important for them to know. This is not what I said.
Then why was it important to send you this notice, to send you this notice in March 2021 in the first place? If they know very well, why was that notice necessary?
It is their decision, and they send it, and I respect it because it's a rightful notice. And I acted immediately by looking into the assessment of the claim and the quantum, and that's why we appointed the expert. And since there is a result coming from a third party independent expert, we did not feel we have to notify in writing each other's. However, we are fully aware of the report of the expert.
Right. Interesting. Now, in your capacity as, do you know how hotel management agreement works?
What kind of?
I don't know if hotel management agreements, hotel operation, how it works. How are you familiar with this or not?
I have an idea, but this is not my expertise. This is not the area where I'm in charge of.
Okay, let me see if we can agree on some very elementary factors. Now,
yes.
Usually we have the owner of the hotel and we have an operator of the hotel. Very often, in reality, in most instances, I put to you, I stand to be corrected, but based on my experience anyway, in most instances, the owner and the hotel manager are different entities, are not one and the same person.
Okay.
I think we can agree that the owner will pay the hotel manager a fee for the operation of the hotel on the owner's behalf. The hotel manager will not do this for free, will not operate the hotel for free. Right? I think we can agree. They do a business. They have to make money.
That's true.
And sometimes, and here, you know, the sky is the limit, and the human imagination is the limit as to how these arrangements can be. Sometimes, usually, the hotel operator pays a fee to the owner, which is calculated as a percentage of gross profit. Yeah. Sometimes it is the owner that collects the gross profit and pays a fee to the hotel manager, various different forms. But we can agree, though, that the hotel manager will be paid for this job. I think we can agree on this.
That's correct.
And the owner will pay the hotel manager because it's the owner that is the ultimate beneficiary of the hotel that will pay the hotel manager. Am I correct? Do we agree on this?
I'm not sure, because the collection, usually the operator is collecting the money from the guests, and how this is happening, it's not my area, it's not my expertise. I'm just trying to be polite to answer your questions, all your questions, but really, it's not my area, but I assume that the money will be collected by the operator and then distributed.
And so the operator, I'm with you, will collect the money, and then it will give it to the owner. So the owner will, whatever the owner receives is after the operator is paid. Because the operator must make some money. Correct?
Yeah, I mean, it makes sense what you are saying, but let me see where we will reach.
I'm already there.
Okay, good. Excellent. So we established that everyone will get some money against this. I agree with you.
That's exactly what I needed to establish. The rest is with Mr. Millington and Mrs. Claire Levin. As you said, that's your own expertise.
Exactly.
One last question, and we will go back how we started, unfortunately. We will go back to your first witness statement, I'm afraid, Mr. Agildi. The one that we had a very heated debate on day number 1.
Okay.
We looked at paragraph 23 of that particular witness statement. You told me I will read it again. What your language here is, despite the engineer's termination being issued on 5th March, which confirmed the defendant's dues to the claimant, the defendant failed, refused, and/or neglected to give effect to the engineer's termination and/or to make payments to the claimant. And you told me that when you signed this, you signed it on the belief, because you wanted to say here that that Reem did not give effect, that you were right to deduct. You did not want Reem to pay. You wanted the court to say that you had the right to deduct. This is what you testified.
I agree with you. Yes, that's correct.
And you repeat this now. You repeat this now.
Yes, I do.
Yes. Now, this witness statement was in support of a claim of a document, did we find it? That was submitted to the court by your lawyers. The IFC court rules, the rules of the IFC, require that any document with which proceedings commences is accompanied by a witness statement. These are the rules. If you ask me, I'm not sure I understand entirely why a witness statement is necessary, but never mind. Let's see the document. So, and your witness statement is necessary. Without a witness statement like this, the claim cannot be made. Let's look at the claim form as submitted. I don't see anything on screen. That's why I'm looking at you. The screen is black, totally black. I don't know. No, here it is. Is it the same? Excuse me, it's C1, Your Honor.
Yes, I have it.
Yes. Do you see the amount? Is it 7.7 million?
Yes, I can see it.
Is the amount determined by the engineer?
I think it's close to this, but I mean, we can have a look and reconfirm, but it seems yes.
No, actually, it is not, because the engineer determined that you had the right to deduct 5-point-something million. This includes the 1.8. Let's see.
Yes.
What is it that the claim is? The defense. This is the claim form. is indebted to the claimant. It never says anywhere that it does not anywhere in this document there is a request for the court to recognize the right. There is an indebtedness. That's the word. And if you can go down, let's go to the end. Where is it? Says a debt claim. Remedy sought. Let's see. Sorry. Give me. Don't go down.
I'm not sure what's happening. I can't hear what's going on.
Yeah, sorry, yes. So you have this was made, 5 made a claim, asked the court to oblige Reem to pay 7.7 million. It's not a claim to recognize. And you say in your witness statement that there is a debt of Reem of 7.7. What I'm trying to say is that your first witness statement was not accurate. That's what I'm trying.
Yeah, there are details of what is this 7.7 million. Am I right? There are details mentioning what are these 7.7 million. So if the details are referring to the same determination of the engineer with the same amounts, which are to sum up the same amount, I don't see how you see it. It's a bad intention, or we are trying to double claim from Reem. That's not the intention, and this is not what is there. If you are trying to imply that this was our intention, it was not the intention at all. We always stick to the engineer determination, and if we have agreed from our side, like if Reem they have agreed like how we have agreed that this is a rightful determination, then everything would stop there.
Unfortunately, Mr. Akiki,
yes,
it was struck out, this claim, because it was the intention to have Reem pay money that you had deducted. This is why the court struck out the claim. That's what I put to you. This is exactly what the court said, that 5 tried to, I will use a mild expression, confuse. You don't need to comment on this, Mr. Akiki. One last question, and I promise this is my last question. We have an engineer's determination which says whatever it says. In your opinion and your experience as a businessman, in an engineer's determination, one party may agree, the other may disagree. I have seen determinations where both disagree. Are you of the view that the party that disagrees with the determination is entitled to challenge it before a court?
Can you repeat the question? I did not understand. I'm sorry.
Are you, in your opinion, as a businessman,
yes,
and a very experienced one, in your opinion, in your view, if a party in a construction dispute disagrees with the engineer's determination. And let's assume for a moment that all contractual steps have been followed.
Yes.
Is such party allowed to challenge the determination before the court? To say that, ask the judge to say the determination was wrong, the engineer was wrong?
Yes, of course. I believe this is the right of both parties to re-question the determination in front of the court. Absolutely right.
I welcome indeed that at last 5 accepted, gave us this at least.
Sure.
Thank you very much, Mr. Akiki, and
Thank you.
sincere apologies where if I crossed the line.
No problem at all. Fully understandable. This is your job, and I appreciate all what has been done. Thank you.
Sorry, you're on mute.
Mr. Kostel, I think you want to
Yes.
re-examine.
Yes, please.
Do you want a few minutes break?
Certainly, I welcome the break. Yes.
My picture is frozen. I can see you, but you're not moving.
Can you at least hear me?
I can hear you, yes. I can hear all of you. During the break, I'll see if I can fix it. I'm not sure whether it's my problem or your problem. Okay, let's resume in at 1650.
Okay, 1650. Thank you.
1645.
Okay, 1645. Thank you very much.
Thank you.
I'm here, Your Honor. The camera needs to turn to me.
All right.
Yeah.
Thank you.
It's the system that the camera points to the one that makes noise.
All right. And normally you.
Yeah, you can tell.
Mr. Kiki, it's your last session, I hope. Mr. Kostel, your re-examination.
Thank you, my lord. Mr. Kiki, you asked many questions on Monday and indeed today, so I'm going to be referring to evidence you gave on both days as part in terms of my re-examination of you. So I'll try and help you on the answers you gave on different days. On Monday, you were asked many questions about your delay analysis. I think you were asked some questions again today about the analysis that you had put together.
Yes.
And in particular, you said that you hadn't held Reem responsible for delays caused by the subcontractors. And I want to just, exactly, I think you can anticipate what I'm asking. I want to just ask you to clarify what you meant by that.
Yes, you're right, Mr. Martin. I said that, but I said also the main contractor, not only the subcontractors, the main contractor as well. So what I meant by that, Reem, they have said clearly in the witness statement of Mr. Al-Mahdi that there are activities which they may have delayed them. And specifically, namely, they said 3: concrete work, eaves, and marble work. So based on their, I respected that, and I agree with them. It's not like I disagree. I respected that, and I wanted to go with their understanding and with their factual progress on site, how they have done this work. So I took these 3 activities and I proved with documents, without further doubts, when these activities they have been completed. So that's one evidence that I have in my hand to establish my delay analysis. The other, so this is one component. The other component is the contractual document which has been signed by the 2 parties, how to deliver these works, because there is a schedule, detailed schedule, has been attached to addendum number 1 with the main contractor, and the subcontract agreement with Reem refers to the same schedule. So that schedule is a detailed one, which is saying when each and every activity has to finish and when the other activity has to start. And of course, there are some margins and tolerance between the two activities because there are things need to be completed. So based on these two components, which are both contractual and there is no dispute between the two parties of the schedule that has been agreed between the two in the subcontract agreement and between the factual dates, which now, as I have seen today, they are trying to say that the final close up of the edges, this is also part of the eaves, which yes, it is part of the eaves, but it was delayed by Reem. That's why I did not consider these as part of the delay analysis. So to go back to your point, Mr. Martin, yes, I did not factor any delay which may have delayed Reem in their work. I just focus on their own delay after then they have received the three major activities that they have mentioned and when they finish. That's how I establish my delay analysis in a fair manner, I believe, based on what they have claimed.
And I think it might be of assistance if I show you the delay analysis, because what we've done is we've looked at certain documents in the delay analysis, but we've not looked at every single document. And I think it's right that it is looked at in more detail. So, my lord, I'm looking firstly at E1094. This is the well-known, I'm calling it a table, but I hope you understand why I'm calling it a table, or a diagram, if you like, of what you are saying, where the delays were. Yes. And how the 170 days were calculated. We're quite familiar with this document, but what we need to understand is how you get to the conclusions that you get to. And it might be of assistance if you explain it in light, because I've asked you questions now on what you meant. So I'm asking you now, based on this document, how you got there to which conclusion you did. So this is now E1095.
Yes.
And this says agreed scheduled completion date of all concrete superstructural works, 28th of March 2018. So let's take this in stages. Whose works are these?
Can you assist me to read, because it's too small for me? So
well, let me ask you another way. Who did the superstructural works?
The superstructure work. This is China State, the main contractor.
Yeah. Okay. So China State, the agreed completion date you noted was the 28th of March 2018 for the superstructure. Yes.
Yes, that's correct.
Now, just tell us where within this document you get that date from.
We need to go to the last floor, which is level 59, because it makes sense that the building is being built floor by floor, especially we are talking about the concrete floor. So it's not possible to build one floor before then you finish all the others. So the last floor, that's why I went straight to the last floor, which is 59. That's the final level. And I have taken which date was supposed to finish as per the contract with China State, the main contractor.
Right. Now, I don't think Mr. Spawley disagrees with you, by the way. I should say, I think Mr. Spawley also says that the way the works go, it goes up in the floors. So
yes,
progressively you go up, and 59 is the final floor. But in terms of the contractual agreed date for the eaves, because we've heard a lot about this in level 59, this is the date here for level 59 is wing C eaves. Yes. Is the 23rd of June 2018.
Yes.
We can see a highlight. Sorry, not a highlight. We can see, yes, it says here level 59 wing C roof guard and finishes an MEP. Do you see that?
Yes.
So, again, I just want you to explain where we get the 23rd of June from. Sorry, my lord.
What's MEP?
I'll let the witness answer.
MEP is mechanical, electrical, and plumbing. So these are the mechanical services of the building. Yeah.
Yeah.
So yes, Mr. Kiki, just explain to us how we get to the date that you found.
Yes. So the eaves, we need to go to the eaves. I really cannot see. It's too small for me, the screen. But we need to see if you can assist me. What is the eaves section? So the roof garden, terraces, light, action, scaffolding, MEP down, installation.
Let me ask you another way.
Yeah.
How do we know that the wing C is the final wing for level 59?
It's ABC. You know, there are 3 wings, and it's very simple. We name the first wing A and the second wing B instead of saying 1, 2, 3. So that's how it is structured.
Okay.
But we need to go to the eaves, and then we see what is the date.
Okay, so there's one that's highlighted here.
Yeah, roof garden, walls, and ceiling rendering. Yes, sorry. So rendering is the same thing which is eaves, because eaves is rendering are the same thing. So that highlighted yellow is the scheduled agreed as per the subcontract agreement, the dates when they were supposed to finish, which is 23rd of June 2018.
Yeah. And then this one again, we look at balcony of last floor 59, last balcony of wing C. Again, you mentioned C.
Yes.
And you've said it's the 10th of June. So again, here we've got the finishes in the MEP level 59 wing C balcony.
Yes.
And then just scrolling through, I think you highlighted to rendering.
Yes,
and this
10
is
2018. Yeah.
And then the next point here is for wing C, level 59, tiling for pool and garden completion agreed. Contractual date is 4th of July 2018.
Yes.
And again, you've highlighted.
Yes. Yeah.
And the latest date here is the 5th of July 2018.
Yes, exactly.
There are earlier dates, but for the purposes of the date of significance is going to be the 5th of July.
Yes, I mean, to be fair to Reem, we have to go to the last agreed date, not the ones before that.
And wing C again for Reem's curtain wall glass completion date is again 5th of July, and that is here in green.
Yes, the wall,
5th of July. And for the glass balustrade completion, that's also the 5th of July for wing C, and that's here the 5th of July.
Yeah, that's correct, in blue.
Yeah. And then what we now look at is the inspection request. Is this a work inspection request?
Yes, this is the work inspection request, which is related to level 59, grid T12, sorry, the level 62. Even there were some, 59 is the last typical floor. There were also small floors which are for the elevators and so on. That's why you can see level 62 here. So I took the last floor, even which is not related to aluminium work. So that roof is 62. There is no aluminium work at this level. The aluminium work stopped at the 59. Okay. And based on this inspection, which is the top of the building, the last level of the building, we can see that the date was 5/9/2018.
Yeah.
Yeah.
Yeah. And the inspection date itself was the 6th of September. Yeah.
Correct. Yeah. And if we can go to see if this was approved or rejected or to be revised, we will see that there is a tick on the B, which is approved as noted. So there are some notes, but the works have been approved. And this is my evidence that the last slab of the concrete in the top of the building has been completed by this date.
And you weren't here yesterday, and you won't know this, but you are familiar with the work inspection request log submitted by Reem. You've seen that document before.
Yes, I have seen that.
And we've seen the references to letters in that, A, B, C, D, E.
Yes.
Is that the same as this?
Yes, incomplete resubmit E, and we were debating today, I think the morning, with Mr. Harish, the code E.
Yeah.
Or maybe I was also questioned 2 days ago, what is the meaning of E and why they are E?
Mm-hmm.
So it's the same explanation here, which is incomplete to resubmit. It means the work is not completed yet.
Yeah. But the work, does that mean the work specific to that particular contractor?
Yes, 100%.
Okay. And now we look at the eaves for level 59. And here we've got level 59 zone ABC. Is
Yes.
zone and wing interchangeable, or are they different things?
No, this is the same. So zone and wing, it's the same thing, ABC.
Same thing.
Yeah.
So this is level 59 wing C, and this is
Yeah.
dated 27th of Feb in terms of the inspection
Submission.
date.
Yes.
Sorry, submission date. You're right. You're absolutely right. And the inspection date is the 28th of February.
28th February. That's correct.
And we can see here for the inspection of the works, it's outlined here that the inspection was for level 59, the roof garden, and the grids with covering zones B, A, B, C.
Yes.
Yeah.
Yes, and it's interesting that the correction of the paint, it's mentioned render. So this is to confirm that the render is the eaves. This is just an observation. You see that they dash the paint and they put the render, which is the eaves. This is the engineer definitely has done that.
Yeah.
Okay.
And it says it had ticked code D for information.
Yes.
But the comments here are that the work has been inspected and accepted and approved by 5.
Yes.
So,
correct.
So 5 had accepted this, and as far as 5 was concerned, it was all completed and finished.
Yes. May I explain this, please?
Yes,
So
please.
sometimes the engineer has certain reservation or observation which is not fully satisfied with. And the engineer will ask the engineers of 5 by saying, do you accept this? Like sometimes there are some defects, minor misalignment or something. And if the engineer, they will say, it's fine, it's acceptable within the tolerance that we are happy with, then the engineer puts a similar comment to this one. And it will be considered approved.
And the date that we can take for approval is at the 3rd of March here in the bottom right-hand corner.
Absolutely right.
Okay. And the next inspection request is again level 59 zone or wing ABC, dated the 27th of February 2019.
Yeah.
And again, whose works are these?
So these are the inspection for healing void closure. These are the eaves, again, the same, the renders or the eaves.
Yeah. And here we've got a code B.
Yes.
But the date is February, so it predates March, so we don't need to consider that too much.
That's why we don't consider that. Yeah, correct.
Yeah. This is the tiling work.
Yes.
Again, this predates. This is level 59, and it deals with wings A and B.
Yeah.
But it's not the eaves work, and because it's not the eaves work, it doesn't feature too heavily in the sequence of works, as I think has already been discussed.
Yeah, that's correct.
But this is in here for the fullness of the delay analysis. Is that right?
Yes.
And this was approved on the 30th of January.
January 2019. Yeah.
Okay. And finally, you included factual proof of non-completion date of Reem curtain walls and glass balustrades until 2nd of September, which is the operation date. And I think this is an email from Mr. Nair. Yeah. And we've heard the evidence this morning that he accepted that there was delivery of glass after 2nd of September. So it's not, this is not an issue in the case that needs determination. But we go back to the question at the beginning, which is what was the purpose of this delay analysis?
The purpose of this delay analysis to filter any kind of delay that is not the responsibility of Reem, and to keep only the own delay of Reem caused by Reem without any affecting delays by others. So that's the purpose of this analysis. And based on the factual, based on the handover that happened on site, and these all documents are not disputed by both parties. Also, the schedule that has been attached to the subcontract agreement is a solid document that is not disputed by the two parties. And based on this one, I believe I have done my best efforts to assist in understanding the truth of the delay and the nature of the delay, and where Reem can be held responsible and where Reem are not responsible.
Okay, now we know that there is, I think earlier you may have even said in evidence that as a result of the fire incident, you didn't dispute the entitlement to an extension of time. You weren't even disputing the right to claim prolongation costs, as far as I understand. Correct me if I'm wrong. But you were disputing whether or not they should receive prolongation costs because of not submitting the claim or not complying with the contract or that sort of thing. Is that right?
Yes, absolutely right. And even I mentioned this today morning in my cross-examination with Mr. Carvelis. And I still believe that there should be no objection or no issue from our side for Reem to claim extension of time, even though the discussion with Salim and he said, we will not. I believe that was said that time to just secure at least the 850 or 750,000 in his hand. So I will cross over this. I will not stop there. Even if he said that in his statement, I still believe that they deserve a certain compensation due to the fire delay. And that's why I accepted to put this clause in their subcontract agreement. But instead of turning this clause as a blank signed check to them, where they can put any amount they want, which is not fair to China State, because in my position, to be very honest and transparent, I have no gain and I have no loss if Reem will achieve a claim of 10 million, or if they will achieve 1 million, or if they achieve 100,000 from China State. I have no benefit, I have no interest other than to be fair to the two parties. And that's why the clause 4.5 has been structured in a way that, yes, we will secure to take money from China State and pay you in some conditions. The first condition, they have to default China State in their obligation to take your claim to the CAR insurance and to pay you. Now, if they receive the money and they don't pay you, also this is a default of China State. Let's say this will not happen. We said the claim has to be approved by the engineer and has to be approved by the client. So here I was trying to be as much as possible fair between the two parties, which I have no benefit. China State is not my partner, and Reem, they are not my partner. They are both working as contractors in this project. So back to your point, I have no objection for them to claim extension of time due to the fire delay, and this is the liability of China State to pay it. However, the form and the content of their claim was never serious, was never substantiated. And I believe their mistake is they rely on this clause that it's a blank check signed for them by sometimes minimizing people and saying this and that, and come Nabil and pay, we have a contract with you and you have to pay any amount that we say, which this cannot happen. I cannot go with this approach. I can only rely on the engineer determination, which we all agree that Atkins is a professional and international company, and there is no way that I can. First, I have no interest to influence them to change any claim, so I have no interest. Second, even if there is any intention, it is not possible with this kind of company with this level. So therefore, I believe their determination, it was fair, and we have accepted it, and they disputed it.
In terms of the actual claim for the prolongation itself, we've seen a spreadsheet, one spreadsheet, which I think you were shown earlier today. My learner friend trying to get you to answer in a particular way, which was essentially whether it's a projection of future losses or anyway. We don't need to get into the details of that.
Yes.
But what we saw is a table essentially of staff names and salaries for particular months for a particular period of time. Do you recall that?
Yes, I
What-
do.
So when we talk about substantiation, what do we mean? Well, what is understood?
Uh, uh, if I want to give a live example and very fresh, it's exactly that we have done jointly now in this session. Substantiation, when I say there is a delay, I have to substantiate this delay. I have to go and find evidence and to bring them to the attention of the court and say, this is where the work start, this is where it finished, this is the inspection signed, and this is what I was expecting from Reem to do the same. For example, instead of sending a spreadsheet of the salaries of the employees, which I do not dispute, I do not have any say if this person get this salary or not. That's not the point. The point was this person present at site during this period of the extension of time that they are claiming for the fire delay? And if yes, was present, was he active and productive or no? Or was she active and productive or no? So this is a kind of substantiation that I would expect from a contractor, professional contractor, who is claiming for extension of time, and idle people. Like, he should prove, and I'm sure they have daily reports, because every contractor, they keep for themselves daily report about their productivity, how much work they have done, where they were busy, they were sitting doing nothing, idle. Also, they will mention that there are 10 people, they could not make anything today, they were sitting on site and waiting for other work to happen. So that's the kind of substantiation that I believe it is minimum required for a claim to be approved by the engineer and consequently by us. And especially, we are taking the money of another contractor, which is China State, and we have to pay it to Reem. So we have to be very careful. First, we need to be convinced that this is a substantiated claim. And the first thing I would do, I would give it to China State and hear their opinion, because I want to see how they will react. If they will take it to the insurance company or not, and if they take it, they will manage it properly, the claim, or no. And if they will neglect it, then I will say, you know what, I give you the chance. This is your responsibility. This is your obligation as per your commitment to me. This is the letter. And then the engineer has approved this substantiation claim, and we approve it. And then we do same thing that happened with the 750, 850,000, the same procedure. The same thing happened. Also, the 850 has been given to China State. China State, they told me, you can deduct it from our account at the end. This is verbally. I don't have evidence or documents of this, but they said, if this is what you want to do, deduct it from our account at the end and pay them. So the same. Why the material was approved? Because the material was substantiated, and the engineer has looked into all the details of the burned items in the fire, and the work, and they assessed everything, and they said this is in their opinion 750,000. They did not approve even 850,000.
Now, the question I've got is, did Reem submit the substantiation that you have referred to, the evidence that you're outlining? Was that ever
Yes.
submitted to you and the engineer? And that's when I say you, I mean 5 Real Estate.
Yes, I even believe that they submitted to China State directly first. They did like a photographic survey, and they count how many material they were damaged.
Sorry. That I think you maybe it was poor questioning.
Yeah.
That's
No
the
problem.
materials damaged. I'm
Yes.
referring specifically to the prolongation costs.
Yes, the prolongation cost, it was not substantiated. It was submitted. We all have seen it today, but without any substantiation other than the list of people and how much salaries they take. And this is definitely, the engineer did not take it into consideration and did not take it that it's a serious claim to be looked at.
I want to just ask you, how many? Or let's deal with the period after the fire incident. So we know that 6th of August is the fire incident. The 25th of October becomes the new completion date. So there's, if you like, as you're saying, the entitlement. There is an entitlement that's arisen as a result of the fire, and the experts have described a second period of delay from 25th of October to, I think it was 15th of March, if I'm not mistaken. And then
Yes.
the third period of you agree with that? And then there's a third period of delay from the 15th of March until the 2nd of September. Understood?
Yes.
So
Yeah.
your delay analysis focuses on the 3rd period.
Yes.
Why don't you deal with the 2nd period?
The 2nd period, there were delay by Reem, but also there were delayed by other contractors, like the concrete, for example, and maybe the eaves. So my delay analysis did not hold Reem responsible for any delay, even if they were in delay, which was like at the same time delayed by other contractors.
Which we call concurrent delay in the construction industry, don't we?
Yes, which you call it. You're absolutely right. The concurrent delay. So, I mean, technically speaking, I can hold them responsible, but there is no way to be fair in this. I cannot be fair because I mean to say everyone is delayed and I want to claim from everyone, it's not really an appropriate approach, and I do not believe this is a fair approach. But when you establish that these dates have been completed and the work that is delaying you has been given to you with clear clearance signed by the consultant, by the engineer, and then you, instead of finishing as per the schedule within 12 days or 15 days from that date, you take the full duration of delay, then this is where they are fully responsible for their own delay, which is not related to any other delay.
You will recall, and the reason why I'm asking you about the 2nd period in particular is because you'll recall the cross-examination on Monday of you, where you were being asked about the Dubai civil defence inspection.
Yes.
So I think you may remember that it was over an email, and then attached to the email there was this tape or spreadsheet or table or something like that with input, and questions were asked of you whether Reem was mentioned, and I think you agreed Reem wasn't mentioned in that. But I want to just show you this letter which is in the bundle at page E1085. So E1085, and this is dated the 23rd of October 2018.
Yes.
Do you see that?
Yes, I can see that.
It's for the so I should say it's from the engineer. It's to Mr. Al-Mahdi.
Yes.
And of Reem. The subject is delayed delivery and installation of hinged and temporary glass panels at the locations of the revolving doors. Okay.
Yes.
I think you were CC'd into this letter as well.
Yes.
Okay. Just have a quick read to remind yourself of the contents.
Yes. Shall I read it, or we read it
Just
together?
read it to yourself quickly, because I just want you to remember what this is about. Or what we can do is summarize it pretty quickly.
No, I mean, actually, it's a very interesting letter, and I need to read it again to just remember the facts, how the delay of the civil defense inspection have been directly related to the works of Reem, which in the cross-examination of Monday, I have been questioned if the report of the civil defense doesn't have Reem items. So what is the relation between Reem and so? And my answer was very clear, and it's in line with this letter, which I said, for the civil defense to come to inspect, and I remember there were 2 or 3 trials before then they accepted to come. They did not come because the facade and the elevation and the aluminium work was delayed. And this is another proof, which is saying concerning the mentioned subject above, weekly progress meetings. So it's not only letters, it's weekly progress meeting, MS5 serious concern about the several promises and agreement made by Reem for the delivery of hinges door and temporary glass panels at the location of the revolving door, which supposed to be delivered 10th October, and again confirmed by Reem to be delivered 21st of October. So you see the promises and the delays which are repeatedly happening. However, the doors are not yet delivered as till the date of this letter. So considering the current critical conditions of the project's process to achieve the target progress. To achieve the target completion date and the planned civil defense inspection by the end of October 2018, please be advised that the referred hinge doors and the temporary glass panels should be available and installed on or before 25th of October 2018. Given the above, any delays, so they are holding Reem responsible for any delay that might happen to civil defense due to the absence of these scope of work done by Reem.
Yeah. So what's essentially what's happening here is you agree that there was a civil defense inspection by the end of October. Do you recall that?
Yes, I do.
And that didn't take place. And do you agree for the reasons mentioned in this letter?
100%, because there are two ways that an inspection might be handled by civil defense. They might come to the site. They always come. They will never refuse to come. They will come to site. They will stand up outside. They will refuse to enter the building if the facade is not ready, if the aluminium is not fully enclosed. And this is exactly what happened. And the engineer was warning them and was saying for them, you promised first time and you fail. You promised second time, you fail. Please make sure that this will take place before 21st of October. And this unfortunately did not happen. And that's why consequently the civil defense was delayed. I think we got it approved in March, if I remember, 2019.
And the engineer has referred to the installation should be on or before the 25th of October 2018.
Yes, that's correct.
It's an interesting reference to that date,
Yes.
because that's the date from addendum number 1, isn't it?
Yes, that's correct.
And that was the completion date.
Yes.
And as far as you understand, was the completion date revised at all from October 2018 to any later date?
I would say it was delayed, but not revised.
Fine. Yeah. So next letter, please, which is, just want to make sure I've got this right. So next letter is at E1083, and it's again from the engineer. It's the 14th of November 2018. It's to Reem for Mr. Almaty's attention, and this time the subject is Reem's failure to achieve the project's milestones, project's targeted authorities' approvals, and project's completion. Now, interestingly, of course, this is now after the completion date of the project. Yeah. Okay.
Correct.
Again, I just familiarize yourself with it, but this also deals with the Dubai civil inspection, doesn't it? Civil defense inspection.
Yes, absolutely.
And yeah, so again, it's recorded that there's a failure to fulfill contractual obligations. Yeah. Project milestones, completion, targeted authorities. Which authorities are being referred to here?
Authorities. This is also, I think I mentioned the same thing on Monday. So civil defense is one authority. The other authorities, they are EHS, which is Tarakhis, and Nakhil. So all these will have to be achieved after the civil defense. So first civil defense has to be approved. Then Tarakhis, they will come with the EHS, which is related to safety measures and so on. And then Nakhil is the final approval. So these three authorities, they have been delayed due to the delay caused by Reem to the civil defense inspection and approval.
Now here, just to explain the significance of this paragraph here, that particularly we refer to the recent missed civil defense inspection for the partial building completion on 4th of November, where China State failed to apply for DCD due to non-readiness of the entire building, due to contributed delays by Reem.
Yes, so that's exactly a continuation of the previous letter, where at that letter the engineer was warning them that be careful, if you will not finish on time, we will not be able to do the civil defense and there will be consequences and delays. And this letter is to confirm that they failed to comply with the engineer reminder and instruction to finish on time. And here, given the above, MS Reem Emirates shall be fully accountable for any further failure to achieve the completion of all works related to civil defense inspection. Sorry.
That's right. Sorry.
Yeah, as committed by China State and all subcontractors to allow for successful approval of the scheduled and delayed civil defense inspection for the completion of all works, which is rescheduled till end of November. So again, this is holding them responsible once more that we could not make this inspection. We are rescheduling it, but this time, please make sure that you will finish on time.
Yeah. And there's a reservation of right at the end as well for
Yes.
a claim for damages. And we know that FIDIC 8.7 is delay damages.
Yes, absolutely. So that's again, the engineer here, he was already very alerted and aware that there will be consequence of these delays. And as part of this letter to push them to finish on the reschedule date of civil defense, also he's putting them under notice that if this delay will continue and there will be more delays, so you will be fully responsible as per FIDIC and as per the contract.
Yeah, I was going to say, and also it says here terms and conditions of the subcontract agreement. So it's both are covered.
Both, yeah, absolutely.
Okay, so then just to finish off this topic, so this was the letter of the 14th of November, and then we've got the sorry, 28th. In fact, I think, to be fair, Reem may have submitted this letter on the 15th of November 2018. Mr. Almaty was cross-examined on this, and this is Reem essentially responding to the engineer not accepting the delays and gives its explanation here. So I don't know if you want to familiarize yourself quickly with it.
Okay, I will.
Yeah.
All these are relevant to cross-examination, I guess, Your Honor. All these now, these new submissions.
I didn't know.
These new
Sorry.
examinations.
Mr. Costello?
Just saying.
Yeah.
Yeah, sorry, I haven't heard. Sorry, I didn't hear that.
I'm happy to have Mr. Akiki on record for the rest of the trial. I'm just asking for the sake of the economy of the trial. Is this now re-examination or is it now an extended examination in chief? I say that because it's already 5:25.
We're stopping in half an hour.
Yeah.
With this.
Well, no, that's fine. Although I don't. Now that it's been raised, we are delayed because I'm afraid my learned friend did many times make a lot of speeches requiring answers, and that's delayed the time. This has arisen as a result of the Dubai Civil Inspection cross-examination of my learned friend. It's arising from cross-examination. I'm trying to just give both sides. Yeah.
It's fine. Let's just move on.
Yes.
I thought it was with that topic.
Yes.
But can you tell the document number?
Yeah. E1089.
Right. Okay. Thanks.
So thank you, my lord. So yes, Mr. Akiki, this was a letter from Reem, essentially denying the delays, blaming the engineer and 5.
Yeah.
Do you see all this?
Yes, the main excuse or blame is that the shop drawings are delayed by the engineer. So can you please remind me what's the date of this letter, if you don't mind? If
Sure.
you can go
This
up.
is the 15th of November 2018.
So, yeah, exactly. So can you imagine in 15 November 2018, a contractor is claiming delay because the shop drawings in 2015 and 2016 before the fire incident and during the 11 months of the fire incident that they were not approved yet till 2018. That's totally illogical. So this is proof again that the blames and the excuses that they were using are definitely not the reason for their delay. So the shop drawings, they were submitted in 2015, 2016 before the fire incident. In case of any 1 week delay or 1 day delay in shop drawings, they had 11 months where they could submit The engineer was fully active for responding, for clearing up all the shop drawings. And then after 11 months, we are in 2017. So how come in 2018, November or October, we are still blaming for delay of shop drawings?
Yeah. And then just finishing off this topic for context, we've got the engineer's response on the 10th of December 2018, again to Reem.
Page.
Let me start that. Oh, sorry,
Page.
I'm so sorry. E1087. And this is the engineer's, thank you. This is the engineer's response.
Yeah.
Mr. Akiki.
Yes.
And again, it talks about the materials shop drawing, as you were just saying a minute ago, the shortage of material, newly proposed, it speaks for itself.
Yeah, exactly. I think we just need to read it and not to even comment. It's self-explanatory. So this is, again, they are putting the facts in perspective, and you can see the approach of the engineer, how solid, how factual it is, and the approach of Reem saying, I don't have a shop drawing approved on time in 2016. That's why I delayed.
Yeah, and this final bullet point is is relevant to the issue of the Dubai civil defense.
Yes. MS5 left with no option but to agree with Reem to fix temporary panels. That's a fact, to allow for the scheduled civil defense inspection, where this was accepted by MS5 to resolve this issue. For the time being, we regret that MS Reem denied proceeding further with this matter unless this to be approved by MS5 as a variation. Exactly. Here again, they are the engineer is expressing the frustration that we went through. As an engineer, he's giving instruction to Reem to proceed with the replacement of the glass, and they refuse, and they put us under pressure together with the engineer to turn it into a variation order, which now we know what is the reason for this variation order, because even the variation order was not accepted with delay time. It was accepted for value and for compensation to Reem. But now they are trying to say that because there is a variation order which came in November 2019, that's why we are entitled for extension of time.
Yep. You were asked questions about, but I should say that was the last question I was going to ask about the Dubai civil defense inspection, because then we get to March and then the May letter from the engineer, which we've all looked at already.
Yes.
So that, but is there any other context that you want to add to the Dubai civil defense inspection point? Is that the context?
I think it's more than enough clear with the documents that we have submitted, and they are already in the bundle. They speak to themselves, so I have no further comments on the civil defense matter.
Okay. I think you said, I believe this was on Monday, in answer to questions on the text WhatsApp messages at F1981. And I will get it up for you.
F1981.
1981.
F.
Yes, F for Foxtrot.
Yeah.
I'll put it on screen. Yeah. I don't know if you recall, you were asked questions by my known friend about level 40, the U channel.
Yes.
For one moment, I'm going to take my screen off because I need to look at my notes. So just hold on for 1 second.
No problem.
But I think you were asked about the WhatsApp messages, whether it was reflected in the delay analysis. And you said it was, because the context was that levels 39 and 40 are 2 mechanical flaws, and there was limited work for Reem. Do you recall the exchange?
Yes, I do recall.
And you were asked, I think you said you cannot expect such a detailed, the delay analysis to be detailed line by line. Something to that effect was your answer.
Yes.
And what I want to understand from you is why is that?
in this delay analysis, I have established the evidence that prove where the activities that might delay Reem has finished, and when Reem not finished, but the hotel has operated, which is 2nd of September. It's already established. So now coming back to these levels, which are the technical floor levels, the single reason behind why these technical floors were delayed is because they were used by the cradles that they have been given to Reem to finish their work in all other levels. So so the delay of these floors are in the shade of the delay of Reem for the whole building. I mean, I don't know if I'm expressing myself in a good English, but you know, if you have a big tree and it has a big shade, and if you have a small flower sitting in the shade of the big tree, so you will not see the shade of the small flower. Okay, you see the shade of the big tree, and the delay that has been established and evidenced of Reem for the whole building at all levels. That delay of these floors, 2 technical floors, where the cradles they were given only for Reem to finish their work, it can never be like analyzed, and they cannot take it as an excuse that you did not give me access to these floors earlier, that's why I did not finish earlier. So the floor, why they were not given delay? Because they were used for the cradles, which are serving the other floors for Reem to do their work. So
Yeah.
that's my I try to make it concise, but hopefully it's clear what I'm trying to say.
Yeah, and it might be that we can use an image from Mr. Spawley's expert report, and I'll give the page reference in a moment.
Yeah.
Well, as soon as it loads on my screen. Yeah, so it's page G for golf, 1690. Here we've got this is Mr. Spawley's report. We've got what he says about the stages, level 6 to 17, 8 to 29, 30 to 40, stage C, 41 to 49, and then stages E, which is the top floors and the podium as well in the basement.
Yes.
And so and then we've got an image here in the middle of the screen on what we call the typical floors. So just explain the difference quickly between typical floors and mechanical floors, just so I can, because it may give context to what you were just saying a minute ago about the cradles.
Yeah. To make it quickly, there are 4 comments or 4 arrows in this image, right? There are 4.
You mean errors or areas?
No, arrows and comments, like message box. There are boxes, 4 boxes, 4 arrows, right?
You mean these, yes?
Yes. There are 4.
Yeah.
There are 2 at the right and the left, 1 at the right, 1 at the left, and there are 2 in the middle, right?
Yeah.
So the one on the right and the one on the left are also applicable for the mechanical floor, for the technical floor, which is the balustrade.
So let's name them. So the glass balustrade balcony, is that the one you're talking about? And the glass balustrade roof garden.
These are both applicable and similar to the technical floor levels. Now, the other 2 central comments, which are stick curtain wall and doors at roof gardens, these do not exist in the technical floors. And also similar to this, SCW and door balconies, the other area of the big glazing, which is the majority of works. So all these areas do not exist in the mechanical floors.
Okay, so it's really this here.
Yes.
So the glass balustrade and the glass balustrade for the roof garden.
Correct.
So this is the balcony area, and this is the roof garden area.
The roof garden area. That's correct.
Now, in terms of the works that were to be done to the levels 39 and 40,
yes,
cradles were attached to it. I think your answer was earlier in the week.
Yes.
And in terms of the delays, just explain why the cradles were needed for the other floors.
Yes. So the building is too high. We could not use one cradle for the whole building, so we used two sets of cradles. For the upper part, which is covering level 60 or 59, 60 the roof, down to level 40, it was one set of cradles. So the cradles, they are hooked at the top level, which is level 60, and they are suspended and they park at the level 40. So to be able to park these at level 40, you cannot put the balustrade early. So the glass balustrade should not be there, and also the concrete parapet should not be there. Now we move to the lower part of the cradles. Level 39 is the hooking floor of the lower part of the cradles, and they go down to the level 6, which is the last floor above the podium level, and they park there. So these floors, due to the presence of the cradles and the structure that you need to connect them to the slab, there is no way that you can install the glass balustrade earlier than you remove the cradles. And these cradles, they were used mainly for Reem to do their work and the process of finishing all the facade works, which they were delayed, and consequently the technical floor, they were delayed as well.
Okay, understood. And in fact, what we can do also here, we can also show on using these diagrams the A, B, C wings as well.
Yes, that's correct.
And these are the typical floors, as in not the non-mechanical floors.
Yes.
But there's a slight rotation to them.
Yes.
As you go up the floors.
33 degrees every floor. That's correct.
Yeah. As you can see in this image here.
Yes, that's correct.
You were asked questions earlier about in relation to the photograph. I don't know if you recall. It was the photograph of the outside, and you were being asked questions about the eaves. And
Yes.
So can you show us on this diagram what you were trying to explain earlier?
Yes. So again, let's take the far right or the far left, the far left comment, which is the glass balustrade roof garden. So you can see a transparent part, which is representing the glass on the facade. It's transparent panel. Yes, this is the glass.
So I'm going to use my mouse to try and assist you. You tell me where to point. So I think you're referring to this bit here.
That's absolutely right. So this panel is the glass balustrade for the roof garden. Now, this panel sits in the U channel and the grouted U channel and the parapet that we all know due to the nice description of Mr. Al-Mahdi. Now, this part of the eaves, which are the edge of the balconies, okay, these cannot be finalized unless the setting is being done by Reem, which is the first thing to be done by Reem. Then the main contractor has to install the U channel, and then the glass has to be installed by Reem, and then consequently the last thing is to put the eaves after that, and then to put the cover, which is very small part, making a termination between the eaves and the glass balustrade. So that's what I was referring to in the morning explanation, versus the huge surface of the eaves, which you can see them anywhere in the building. So if we move,
so just pause one moment, because I just want to understand what you just said. Is it the roof garden section that you're describing?
Yes, that's correct.
Okay, so it's this half. Well, I call it a half, but it's this section.
Yes, this section.
Okay.
Which is similar to the balcony section as well. So if you move to the extreme right,
yes,
yes, it is exactly the same detail. So there is no difference in this particular glazing between the balcony and the terrace. So it's the same applicable on both sides.
But in terms of when Eaves does their work first or second, which side are you? Is there a difference between the two sides?
No, the difference is between what I was trying to explain, and then you asked me the question. So the eaves, the eaves which are related to the central.
Excuse me. Excuse me to interrupt, but not that it really matters, but the question I asked was on a totally different issue, but please feel free and continue.
Thank you.
Just for the record, I asked, my question was a different topic, not on the re-examination topic, but please do continue.
Okay, well, as there's no objection, Mr. Akiki, please continue.
Thank you. So now we move back to the other areas of the eaves, which are the majority of the areas. So you see where is the SCW and doors, roof garden, the central comment, and the arrow is going there where there are yes, the windows, and also the other central one, which is SCW, doors and balconies. Okay, yeah, correct. So these two areas, the eaves has to finish first before then the aluminium will be installed. This is absolutely right, and that's why in my delay analysis I clearly went to the last floor of the completion of the eaves. However, the balconies that we just discussed now, 2 minutes ago, regarding the garden terrace balustrade and the balcony balustrade, the glass balustrade should be installed before then the eaves close around it. That was what I was trying to explain in the morning. Yeah.
Okay.
Now that Mr. Akiki finished, can my dear friend ask him to show the master bath locations, which was the question that I asked the morning, because you had him 15 minutes giving a speech, but not on the question that I asked, which are the master bath locations.
If my learned friend just holds on, I'm sure if my learned friend just holds on, I'm sure we'll get to there. So
just because so we understand each other, that's all.
So Mr. Kiki, I'm going to now show you, if I get the page reference right, which should be F444. Hold on, bear with me because I need to get it open.
What are you looking for, Mr. Costello?
It's a diagram.
Don't feel obliged by anything Mr. Carvelis says to go to any particular document. Mr. Carvelis has had nearly 2 days to cross-examine, and you must be allowed to re-examine in your own way.
Well, my lord, I'm very grateful for that.
But you only have an hour.
I can, yeah, no, I've got an eye on the time as well. But I assure my lord that I'm not being distracted by Mr. Carvelis' interjections.
Good.
I don't want to distract. That's why I raised my hand, Your Honor.
What do you want to say? What do you want to say?
As I said, I will not object. I did not object to the line of re-examination of my colleague. I'm just wanted to establish, is re-examination on questions raised, or is it re-examination full stop? Because my re-examination was very limited for one witness and to questions raised.
Yes, but your re-examination was after cross-examination lasting only a matter of an hour or two. This re-examination is after a day and a half's cross-examination, and it seems to me to arise out of the cross-examination. That's my ruling. Thank you.
My lord, I'm grateful. I'm just waiting for the image to. Okay, it's come up.
What are you looking for?
So yes, the page reference for my lord is F for Foxtrot 444.
Yeah.
And I'm having some technical problems, but I've got the native document open, and I can assure it's the same. But I'll show it on my screen so we all know what we're looking at. This is a diagram where I'm going to ask Mr. Akiki to identify, but this is the balustrade detail at the garden area. We can see that written here.
Yes.
So, Mr. Akiki, first of all, are you familiar with this diagram?
Yes, I am.
And I want you to explain this diagram because it's arising out of the cross-examination on the fascia and the eaves and when they finish and when the glass balustrade finishes. So I think if you can use this diagram, it might be of assistance to the court. Let me just make it slightly bigger so we can all see it. Okay.
Yeah.
So what's this here?
This is a section on the glass balustrade. The dark part of the section is the glass balustrade. So there are the vertical dark, like blue, purple, is the glass balustrade. On the right hand side is the garden, the terrace, and on the left is the void, the outside, the air. Okay.
Yeah.
And if we see there is like a insulation rock wool, it's a vertical 2 lines, and there are like insulation. Yes, exactly. These are behind the eaves. So this is part of the eaves. This is part of the eaves. And of course, the vertical cover is the cover that Reem they were referring to, the vertical one. And then the horizontal one. The horizontal was the cover that they were referring to, Reem, that they put the last thing, the cover.
Is
and
it
the
this
seal.
here? Is that
Yes,
is that this?
that's correct.
Yeah.
That's correct.
Yeah.
That's correct. And then the vertical part is the eaves, which is outside of the building, outside. So you can
So
see.
this,
Yes,
is that this side? Yeah.
that's the side. So if we go to the sequence that
is the outside of the building, is it?
This side where my mouse cursor is going on. Is that right, Mr. Kiki? Is this the outside?
Yes, that's correct.
So as
That's
we are
correct.
looking at the left-hand side. Yeah. Okay. You
Yes.
carry on.
Yes.
And in fact, sorry to interrupt you. I think
Yes.
I've just spotted something which might help. I think it says inside here.
Yes, inside, exactly. And this is
Yeah.
outside.
Yeah.
Thank you.
Okay. Yeah. You carry on.
Yes. So we can see clearly that the glass balustrade is inserted between two bodies. Okay, these are the concrete parapet and the U-channel and the grouting, and also the setting should have taken place there, and the glass balustrade has to be in place in order to continue the outside part, which is the eave. So here, this section clearly shows that the work that are described by Mr. Al-Mahdi and the sequence of the work, including the U-channel, the setting of the location of the glass balustrades and the parapets, up to the level of the glass is standing up and standing, and then you can close the upper side. So this is exactly confirming what I was trying to explain, that part of the eaves has to wait for Reem, is different than the other areas, which the eaves has to finish first, and then the aluminium should follow.
So in very simple terms, and you'll forgive me for having a very simple mind, but
No.
the glass goes in,
Yes.
the eaves comes on.
Yes.
Is
Correct.
that in very layman, simple
Yes.
terms? That's what happens.
Simplicity is the best way to explain difficult things.
Okay.
Yeah, that's correct.
Okay. I'm just going to stop sharing just so I can look at my notes, because there's another diagram just to quickly look at. I'll give the page reference. The next one is F for Foxtrot, 1216. Okay, and let me just share my screen. Sorry. Now here, let me just slightly zoom out just so we can see what it says at the bottom. This says balustrade detail at balconies.
Yes.
So just remembering the image that we had, you won't be able to see it unless I zoom in slightly. This is the image from Lee Spawley's expert report. Okay, and you remember on the right-hand side, it said glass balustrade balcony, and on the left-hand side, it said glass balustrade roof garden. So the image we're now looking at, it says balustrade detail at balconies.
Yes.
So we're looking at the balcony side, is that right?
Yeah, that's correct.
Okay, so here, I should say these are all the same diagram. This is all the same, but one is more enlarged than the other.
Yes.
So this is the full image. This is a more detailed image of how the installation takes place, correct?
That's correct.
So let's just, if you need to look at the enlarged diagram, we will do, but I think it might be easier if we look at the more zoomed out version, which is this one. So again,
Yes.
this looks like the glass.
Yeah.
Now tell us here how the installation works here.
Yes, so this is the glass, and then you can see that there are the U channel that it was described. So the U channel is also the scope of Reem to install. So Reem, they have to install the U channel and the glass balustrade. The grouting is by the main contractor. So grout is like some concrete liquid they put around to make it more like solid. And then you can see outside how the eaves comes and close on the U channel. So it is impossible.
Again,
Yeah.
sorry, this is the outside because it says
Yes.
here outside. It's a bit faint.
The,
But I
the
can
left,
just, yeah.
yes, the left is the outside, and that L shape that you can see there is the eaves. So this is the render. This is the eaves, correct? So that profile is coming and sitting on the U channel and the glass balustrade. So imagine there is no glass balustrade, there is no U channel. So how the eaves can be built and fixed and to the level, to the exact level where, like with an assumption that where the aluminum will come. So that's why the common sense here and the common practice is that you finish the balustrade and then the eaves will close after the balustrade.
Yeah. So, but in the sense of maybe just to make sure I've got this, in terms of the sequence of works, can the
Yes.
eaves be installed? Because I think on the last diagram, let's compare it to the last one we looked at. On the last one, the glass goes in, the eaves comes on, like like this. Yes.
Yes.
In
Yes.
this one, the glass comes in, but can the eaves be done before the glass?
No, because you see the U channel. So in this case, the eaves is not closing at the glass, you are right, but it's closing at the U channel. And that's why the U channel has to be, I mean, if I want to be more accurate, I would say at least the U channel has to be installed first, and then the eaves can close. But technically, practically speaking, you will not do that because you don't want contractors to clash when they are working. So you give the Reem the access to do their installation of the glass and the balustrade, and then the eaves will come close one time. So they will not come and go.
Right. Thank you for that explanation.
Thank you.
I've got an eye on the time. I'm just going to see if there's something else I can quickly re-examine on. You were asked about Reem, your experience with Reem at the 5 Palm Jumeirah. And yeah, I think I'm not sure if it was quite put to you, but the tenor of the cross-examination was why you didn't terminate Reem if they were so bad. Why didn't you terminate Reem?
I don't want to use one saying which is not appropriate. I mean, dealing with the known contractor is better than to deal with an unknown contractor. Okay, I would put it this way. So I prefer to deal with a known contractor than to deal with a non-con contractor, especially at that point of time. So imagine if I want to take a decision to terminate Reem, after then they have done several works, after that they have done the shop drawings, after then they have installed a substantial amount of work. And after then we sign the LOI and the work order. Terminating them, I mean, from my side as a CEO, I have to assess, shall I continue with the same contractor that I have known, taking into consideration all the problems that we have faced at the Palm, or to terminate and go for another venture with a new contractor. For me, if I assess the risk, my risk, it was higher to terminate them and to start to negotiate with the new contractor and to redo the whole shop drawings. So the project would have been delayed further. So I had no other choice but to continue with the known contractor than to go for an unknown contractor. That's my answer.
I'm going to squeeze in one other quick question.
Very quick.
I'll ask it quickly. So you asked many questions about whose idea it was to include 4.10, whether it was yours, whether it was Salim's, whether whoever. And you were asked many questions about the effect of 4.10, etc. Ultimately, it was signed. The subcontract agreement was signed, correct?
Yeah, that's correct.
And you were there were emails, weren't there, that showed that Reem was negotiating 4.10, and you were copied into those, weren't you?
I need to see this, Mr. Martin. I'm really sorry. I can't recall
Okay.
like this.
I'll tell you what, my lord, it's a bit risky if I go there. But I can assure the court that the re-examination that I would have tomorrow may be 10 minutes at most.
But we're not continuing this witness tomorrow, are we?
Well,
We have-
if I can try and...
2 days. That's why I said at the beginning, you had until 3 o'clock.
Understood. If I can try and get this email up, then I will do my very best. 1946. My screen is frozen. Well, it's
Just give a page number. This,
I think that's the problem. I'm not sure I've got one. I think it was E380, but I don't think that's right. Sorry, F2820. I mean, I think that was the page reference, but in fact, I've got another screen. I'll see if I can get it up on that one. Yeah. Okay. I think I'm back.
I may have it if it helps. I think I know what you refer to. I might be able to.
I've got it. I've got it.
Okay.
I'm grateful.
Okay.
I'm grateful. I've got it. It's just come up. This is an email on F2829.
Yep.
It's from Vimal. It's to you, Nabil, Akiki. You'll see. Sorry, it's to Salim. You are CC'd.
Yep.
You can see that, and you can see some comments below. Again, Salim has emailed you in June of 2018 on the day of the signing of the agreement.
Yep.
It's to Vimal. Again, you're CC'd, and many others. And we can see here clause 4.10 comments here. 5 has introduced defaults of other contractors and subcontractors. Don't worry about whether their advice is accurate or not. That's not the point. The point here is that this is an email from Reem to 5. Sorry, this is an email from Reem to 5 based on comments from Reem's legal department. Do you see that?
Yes. I can see that.
And you were asked many questions about the negotiations of clause 4.10 and the like, but you were copied into emails where Reem's legal department were considering the effects of 4.10.
Yes, exactly. So this is also supporting my statement that it has been a subject for discussion before signing as well.
Yeah, and you say that there was verbal discussions, were there?
Definitely.
Yeah. Okay.
Thank you.
Thank
That's very
you, my
helpful.
lord. Yeah, thank you, my lord. That concludes my re-examination. Do you have any questions for this witness?
no, I don't. I think he's answered everything.
I hope so. Anyway, thank
Well-
you. In which case, time to draw stumps for today, I think.
Well, thank you, Mr. Akiki. If your counsel can stay on for a moment. Thank you, Mr. Akiki, for your help.
Thank you, my honor.
You're free to go now. Thank you.
Thank you very much, everyone. Thank you.
Now, tomorrow and Friday, we have 5 expert witnesses.
Yes.
Now, we're going to have to finish them.
Yes.
We can do it 2 ways. We can divide the 2 categories of experts up and have one category one day and one category another day, or we can do some other system. If we did it on the basis of having the Mr. Lowe, Mr. Small, and Mr. Craig, who I think all cover the same topic.
Yeah.
If we have them all, then it would be, we could allow 2 hours each, for example.
Yes.
Which would mean the examination in chief was limited to 5-10 minutes, re-examination no more than 5-10 minutes, and the rest be cross-examination. Or I'm willing to agree some other system, if you like, but that seems to me one way of doing it. Any comments? And the same on Friday with just the 2 witnesses then. Now, you may think the 2 witnesses on Friday don't need a whole day between them, in which case we could spill one of tomorrow's experts into Friday. But once we've agreed something, we're going to stick to it.
Yes. Can I give my input? And then I don't know if my learned friend would mind if I just give my input really quickly. I would suggest that Mr. Millington and Miss Levine would be far shorter than Mr. Lowe, Mr. Spalding, Mr. Craig, because there is a joint memorandum between Millington and Levine, which I'm sure you've read, and you would have seen that the real issue there is, as I outlined in the opening, GOP, NOP, and some other points. My own friend, I understand, will probably have some more cross-examination in terms of the details, the minutiae, but I still would think that Millington and Levine can be dealt with in far shorter time than Lowe, Spalding, and Craig.
Is that your view, Mr. Cavadas?
No, actually, in my view, we won't need much time with Mr. Lowe. His expert opinion is, okay, we'll see. We may need more time with Mr. Millington on Friday, and we have certain limitations. As I said, Ms. Levine is flying, will be in the air most of tomorrow, and she will be available all day Friday. Conversely, Mr. Craig there's a very serious family health issue that obliges him to be on the plane on Friday. So we will need to finish with the experts, the technical, if you like, experts tomorrow. I have no objection to, actually, I think that would be the appropriate, in my view, that's the appropriate way, very truly short, not 45 minutes long, examination in chief, followed by short actual re-examination, and in between cross-examination. I'm pretty sure that we can do it tomorrow. If this means that Friday we can finish earlier, so be it. We might want, it's up to you, Your Honor, but you might want to consider on Friday whether you would like on-the-spot oral closing, apart from the written closing which the schedule provides for. You may want, and we can do this Friday afternoon.
Okay, so are you happy then that we have, just looking at tomorrow, if we did all 3 technical experts tomorrow?
Yes.
That would mean five minutes in chief, about 5 minutes in chief, no more than 5-10 minutes in re-examination, and therefore 1 hour 45 minutes Each of them would take 2 hours in total.
Yep.
Yep. Well, and what I suggest is we actually fix the time. Mr. Lowe between 8 and 10,
Yes.
then have a 10-minute break.
Yes.
Mr. Spawley between 10 past 10 and 10 past 12. So I'm talking UK time.
Okay.
We stop for lunch for 1 hour. And then Mr. Craig between 13:10 and 15:10.
13:15, I think, because you said we will stop at 12:15 UK time, 1 hour break.
I said we stop at 12:10, 10:10 to 12.
Okay.
Second witness is 10:10 to 12:10, then lunch. Then third witness is 13:10 to 15:10. Does that make sense? And is it doable?
It is as far as I am concerned, Your Honor.
Yes, I think it should be.
And I think what's going to happen is if 10 minutes before the end of every witness, I will ensure that there is time for re-examination, if necessary, just by stopping the questioning. All
Yes.
right?
Yes, Your Honor. Understood.
And after 5 minutes of examination in chief, I will stop the examination in chief,
Okay.
if
Thank
you're
you.
happy with that. And then we'll do a similar exercise on Friday. And we'll consider the question of oral submissions.
I'm not
then.
I won't insist on a definition of the word happy, but,
Yes,
we're certainly content with it.
yeah. I think it'd be awful to finish this case with 1 witness outstanding.
Yeah.
It would not be satisfactory. At the moment, I'm not inclined to have any detailed submissions on Friday, but if parties want to spend half an hour just summarising the main points, it would no doubt be helpful. But you and Mr. Carvelis can agree on that. I either both do it or neither does it.
Yes.
I do agree.
And it would not be in substitution for written submissions. It would be simply an immediate summary of the main point. Okay. Right.
Yes.
Thank you very much.
Thank you.
We'll resume at 8 o'clock, 11 o'clock your time.
Thank you.
Thank you.
Yeah.